In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons acting individually or in combination with others in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. Senator Ervin's Watergate investigation today successfully fought off several high-level attempts to curb its activities. Confronted with the first reluctant witness pleading the danger of a prejudiced trial, the committee unanimously voted to force him to testify under threat of contempt of the Senate. Chief Federal Judge John Sirica dismissed an attempt by Special Watergate Prosecutor Archibald Cox to black out television coverage of some witnesses before the committee. That applies immediately to the two men who reportedly have the most dramatic stories to tell, Jeb Stuart Magruder and John Dean. Judge Sirica granted both men immunity to appear. Magruder, number 2 man in the Nixon re-election committee, will probably appear tomorrow. And Dean, the White House counsel Mr. Nixon fired, will appear next week. Finally, both Republican and Democratic members of the committee briskly dismissed the much-publicized charge by Vice President Agnew that the televised investigation was a gross perversion of justice. The message from the committee today was full speed ahead and damn the torpedoes.
Judge Sirica's decision ended a delay of several weeks in getting immunity for Dean and Magruder. Special Prosecutor Archibald Cox said he had no plans to appeal the Sirica decision. Sirica also ordered John Dean to appear before the federal grand jury here in Washington, and Dean did so later in the day, and according to press reports, took the Fifth Amendment.
There were 2 chief committee lawyers, Sam Dash and Fred Thompson, absent today. They were preparing for the next witness and prepping Jeb Stuart Magruder, who could answer a lot of the questions that have been raised in the past few weeks.
The Georgetown University Law School here in Washington watched today's proceedings with us. Mr. Greenhall, Maurice Stans' testimony presented the committee with its first major legal hassle over the testimony of a witness, did it not?
Yes, it did. Robert Barker, who is chief counsel for Mr. Stans, leading a battery of attorneys in the hearing room, read a lengthy opening statement objecting to the hearings because he felt that they could prejudice his client's right to be tried by an impartial jury in another jurisdiction.
And Senator Ervin, as you will see, complimented Mr. Barker's presentation and then turned him down, and the whole shooting match continued. We'll be back with Bill Greenhall at the close of tonight's broadcast to discuss that and many other aspects of today's session. He will be joined by Alan Barth, Washington author journalist, who also watched today's session.
But no one even mentioned the Vesco case today except to assure one another that they weren't going to talk about it. They talked instead of the large amounts of cash that Stans handled, including $75,000 he'd handed over to Herbert, the president's personal lawyer, without even getting an explanation of what the money was going to be used for.
On the 29th of June, I received an urgent call from Mr. Kalmbach. He said he was in Washington at the Statler Hilton Hotel. It was extremely vital that he see me right away, and he wanted me to come over there, and I did. I dropped everything and went over to see him. He said, I'm here on a special mission on a White House project. I need all the cash I can get. He said, I don't have any cash to give you. Will you take a check? He said, no, I can't take a check. It must be in cash, and this has nothing to do with the campaign. But I'm asking for it on high authority.
What high authority did he say?
He did not say. I'm asking for it on high authority, and you will have to trust me that I have cleared it properly.
And later tonight, you'll hear Stans say which high authority that was in the White House. Between his testimony and that of Porter today, there was an eloquent debate over which branch of government should pursue the Watergate investigation. To help you plan your viewing, here is an hour-by-hour rundown of today's testimony. In the first hour, campaign scheduler Herbert Porter details what he spent cash on, including several payments to pranksters during the primaries. He admits purchasing equipment to use in viewing photographs of memos from Senator Muskie's headquarters. His secretary retyped some of them. The second hour finds Senator Ervin in a constitutional debate with Robert Barker, attorney for Maurice Stans. Barker, in urging a postponement of Stans' testimony, asks the committee where can he get a fair trial in the light of the blanket of publicity. In explaining why the Senate was moving ahead, Senator Ervin charges that the electoral process has been polluted. In the third hour, Finance Chief Maurice Stans testifies that he had no knowledge of either the Watergate operation or any campaign sabotage. When he's asked about a memo suggesting that Stans had a political fund within the Commerce Department, Stans says he knew nothing about it. In the fourth hour, Stans tells of a meeting with the president's personal attorney, Herbert. He says he gave Kalmbach $75,000 for a special mission, with authority, he said, from the White House. Later, Stans says John Dean called him and asked for $22,000 to replenish a White House fund. Stans says he doesn't know how the money was used. Now to the hearing itself. As Senator Ervin gavels the committee to order, the witness, Herbert Porter, continuing his testimony from last week.
The committee will come to order, and the witness will return to the stand. Let's see, who had, you remember whose last name? Senator Norrie, I believe it's your turn to question the witness. I believe that's right.
No, I finished yesterday.
Well, Senator Garney.
Thank you, Mr. Chairman. Mr. Porter, to get caught up to date, as I understand it, you were the director of scheduling at the Committee to Re-elect the President, in charge of the Speakers Surrogates program and also the celebrities, entertainments, and athletes. And I think that the two pertinent pieces of testimony you gave us last week was that you had disbursed some $69,000 in this, I guess you might call it, sabotage program, and that you also perjured yourself at the trial at Mr. Gruder's request on what you paid money to Liddy for. Now then, I'd like to clarify one or few points here. Would you explain to the committee how you dispersed the $69,000? I don't think that was gone into in much detail last week.
Yes, sir, I will. Pre-April 7th, I passed approximately $31,000 to Mr. Liddy. The purpose, the funds to be used for a purpose I was not aware of. I passed $8,000 to Mr. Richard Howard at the White House at Mr. Magruder's request.
What did he use that for?
I do not know, sir.
Did you ask Mr. Liddy what he was going to use his money for?
No, sir, I did not.
Go on.
Mr. Magruder instructed me to pass Mr. Liddy funds when he requested them, and I did not ask him what they were used for, nor did he tell me.
Go on.
I gave $300 at Mr. Magruder's direction to Mr. Douglas Hallett, who was at the White House, who worked on the, helped us put some reports together, and it was, I do know the purpose of that. That was to pay round-trip airfare for Mr. Hallett to California for Easter vacation, because he had helped out on the campaign putting these reports together. I paid $1,100 to Lionel Hampton for a band appearance in a rally down in Miami, Florida in March. I paid approximately $3,700 to $3,800 to a Roger Greaves in Los Angeles. I paid...
What was that for?
Mr. Greaves, on two occasions,
promoted some sign-carrying placards to greet, I believe it was Senator Muskie, upon an airport arrival in Los Angeles, and also came on to the, was also paid for a period of about 2 weeks, served for a period of about 2 weeks, and actually was paid a month's salary in effect to do some Dick, as I said the other day, some Dick Tuck type prank harassment in New Hampshire and Florida, and it lasted for about 2 weeks, and he went back to California.
Go on.
I gave $200 to Mr. Robert Mardian for an advance trip to California that he took, and the bank was closed. I gave approximately $300 to about, I would say, 7 or 8 people in various spots around the country to promote the president's campaign at opposing candidates' stops, signs that would say, "This is Nixon country," or whatever.
You gave each one that amount?
No, sir. Total aggregate, approximately $300 to pay for signs and paint and maybe a keg of beer afterwards or something like that. I paid $100, I believe approximately $100, or to Mr. Roger Stone on one occasion to go to New Hampshire to leave a leaflet, I believe, at Senator McGovern's headquarters. And I paid another $200 to Mr. Stone, the same Mr. Stone, to go a second time to New Hampshire to make a cash contribution to Mr. McCloskey's campaign. These were all at the direction of Mr. Magruder. I gave Tom Bell $350 at Mr. Magruder's direction for the printing of a small pamphlet having to do with Senator Muskie's candidacy. Approximately $25 went for stamps, and about $1,000 approximately went to Mr. Magruder on about probably 2 or 3 occasions where his aide would come and say, "Jeb wants $300 or Jeb wants $500 or something." I did not know the purpose of that. And I gave approximately $3,000 to Mr. Ken Reitz, who was then the youth director, or director of the President's youth campaign. The total amount that was passed in the pre-April 7th period was approximately $49,500. After April 7th, I gave $3,300 to Mr. Liddy at Mr. Magruder's direction for a purpose I did not know. I gave approximately $90 to my chief scheduler, Mr. Curtis Hurge, which I understand was passed on to his secretary to pay for her parking for 2 months rather than a raise. I gave another $450 over a 3-month period to the same Mr. Roger Stone for a salary supplement until such time as I could talk Mr. Odell into raising his salary to $550 a month. I gave $4,400 to Mr. Phil Joannou at Mr. Magruder's direction. I did not know the purpose of that money. I gave $4,000 to Mr. Robert Odell on 2 occasions of $2,000 each. I did not know the purpose of that money. I think I took out about $300 for cash expenses on the trip to California with the Mitchells and the Mardians and the Magruders and the LaRues on the weekend of the 17th. I gave $750 to Mr. Ken Reitz on 2 occasions. One, I think, a $300 payment, the other one a $450 payment. I think Mr. Reitz told me what that money was used for, but I don't remember whether it was the first or the second time that he told me, but I understand later it was for the young gentleman that was sitting out in front of the White House, Mr. Brill. And I made total payments of about $6,000 over a 3-month period. Again, to Mr. Stone, that was passed on to a Mike, I can't remember his last name again now. I believe it was McMinoway from Louisville, Kentucky, who worked in 2 or 3 of the primary campaigns as kind of an eyes and ears and kept the campaign, or kept Mr. Stone informed of morale and just kind of movements and that sort of thing. That totaled about $19,000. The total is approximately $69,000, $52,000 before April 7th and about $17,000 after April 7th.
When Mr. Sloan was testifying before us, he testified that he had given you $100,000, as I recall. Can you account for the discrepancy in your testimony and his?
Senator Gurney, this discrepancy was brought to my attention around early July of last year, and I, at that time, said that Mr. Sloan was wrong, and that it had been approximately $65,000 to $70,000, and that Mr. Reesner, I had asked independently to come in and check those amounts. Now, I can't account for it any other way than to tell you that that's my best memory of the approximate amount that Mr. Sloan passed to me. I noticed in Mr. Sloan's testimony on Thursday that the figure $100,000 that was up on the board, that was the one figure that he was a little unstable on and unsure of. And he did say, I believe, that he wasn't exactly sure of that amount, and that was the best of his memory.
Did you and he ever get together and reconcile?
No, sir, not at any time.
Amounts of money?
Never.
One thing that's been a puzzlement to me is why you dispersed money to Liddy at all, because Mr. Sloan also testified that he dispersed something like, used to me, $199,000 to Liddy.
Yes, sir.
So why didn't Liddy go directly to Sloan for all the money? Why get some from you?
I don't know, sir. All I can tell you in answer to your question is that in December, Mr. Magruder told me that Mr. Liddy was going to come to me and that I was to get funds from Mr. Sloan. I was not aware that Mr. Sloan was also giving money to Mr. Liddy. The last money I gave to Mr. Liddy, I think should be pointed out, was in March of 1972, with the exception of the $3,300 that I was directed to give him in the early May of 72.
Did you know during any of this period of time that you were dispersing monies to Mr. Liddy, that he was also getting monies from Mr. Sloan?
No, sir, I did not.
In your testimony last week, too, you mentioned this conversation with Mr. Magruder after he had come from the White House, as I recall. And quoting from the record, you said, he also told me there were going to be several indictments and listed off a series of names, a number of names, people that he thought would be indicted. Who were these people that he thought would be indicted?
I believe, and I would ask the counsel's help on this one, I believe the names that he mentioned were Mr. Mitchell, Mr. LaRue, Mr. Mardian, himself, Mr. Magruder, Mr. Haldeman, Mr. Strawn, Mr. Dean, Mr. Colson, Mr. Dorson. Does that run the list? I don't remember. I think that's it.
Did you and he have any discussion as to why he thought they were implicated?
I'm sorry, Senator. What was the question?
I say, did you and he have any discussion at that particular time as to why he thought they would be indicted?
No, sir.
Now then, let's go to the California visit. That, of course, was when the news broke about the Watergate break-in out in California that morning. And you mentioned that you were at breakfast with a number of people. Now, who were these people?
Yes, sir. I came down to breakfast at about 8:30. This was at the Beverly Hills Hotel. And Mr. Caldero, who was working on the celebrities portion of the day and the activities of that weekend, was with me. We sat down at a table next to Mr. and Mrs. LaRue, Mr. and Mrs. Mardian, and Mr. and Mrs. Magruder. It was during that breakfast, or during that, and I was reading the paper, and I think Mr. Caldero was too, that I overheard Mr. Magruder say, "Does anyone know where I can find a secure phone?" And nobody did, apparently, and he leaned over and asked me, kind of leaned back in his chair over to the next table and said, "Do you know where I can find a secure phone?" And I said that we had a phone, an outside line up in the Mitchell suite, and he said, "No, that wasn't good enough." And I said, "Why do you need it?" And he said, "Well, Liddy wants to talk to me." And that was all he said. And I said, "Well, why don't you just go to a payphone and just pick a payphone at random and call him. I don't know whether he did that or not.
Did he leave the room then?
I don't believe so.
There was also testimony that I think it was your wife in a chat with Mrs. Magruder got the information that Mr. Magruder was on the phone all morning long, as I recall, with Key Biscayne. Can you amplify that any further? Do you know who he talked to?
All I can tell you about that conversation was that Mrs. Porter did mention to me that morning, Sunday morning, I guess she later has now told me that she went in to have a cup of coffee with Gail, I think, Mrs. Magruder, and our rooms were like across the hall, and I believe Mr. Magruder's parents at that time were with them also. And Carol came back and made a comment to me that Gail had said to her that Jeb had been up since very early in the morning, all morning, she said, on the phone to Key Biscayne. That was the net of the conversation.
Did you see Mr. Magruder at all the rest of the day?
On Sunday, Senator?
Yes.
I believe I saw him that morning. He introduced me to his parents, and I said hello to them. And
was there any conversation at any time during this day about the break-in?
No, sir, because Mr. Magruder was making arrangements at that time for air transportation back to Washington, and he left the group and flew back to Washington sometime Sunday morning, I believe.
What other people did you see during that day? That is, principals in this, Mr. Mitchell, Mr. LaRue, Mr. Marty, and anybody else?
Are you talking Saturday or Sunday, Senator?
Well, the day of the morning of the break-in.
Yes, sir. There was a meeting, a California political meeting at the Airport Marina Hotel at about 10 o'clock or 10:30, I believe, and the arrangements were that Governor Reagan was going to stop by the hotel and pick up Mr. Mitchell, which he did, and we went down to the Airport Marina Hotel, and it was at the Airport Marina Hotel that I began noticing a lot of rather private conversations going on.
Between whom?
Among Mr. LaRue, Mr. Mardian, Mr. Magruder, and then ultimately Mr. Mitchell. And there were several large banquet rooms, empty banquet rooms in the hotel that were not being used, and a lot of these meetings were held in those rooms off in a corner. And I was asked on one occasion to stand some 50 yards away or whatever it was and kind of as a guard on the door so they could have this meeting.
Who was
I did not
present at that particular meeting?
Mr. Mitchell, Mr. Mardian, Mr. LaRue, Mr. Magruder, Mr. Clifford Miller from Los Angeles was present, but I'm not sure that he was present at that particular meeting. There were several of these conferences going on intermittently during the morning.
How many would you say?
3 or 4, probably.
And would you please name all the people that you can remember who participated in these conferences?
I think I've named them, Senator, those people.
Did you overhear any of the conversations?
No, sir, not a bit.
Did any of these people repeat to you later any part of these conversations?
No, sir. Obviously, my curiosity became piqued, and I asked, I believe it was Mr. Miller. I think it was Mr. Miller, probably a question like, what's up? And he said, I believe that one of the committee's employees had been caught inside the Democratic National Committee. And I asked him who it was, and he said James McCord. And that was the first time I had learned of that. And that was
how long did you stay
noon.
Excuse me. How long did you stay in California?
I personally, Senator? Yes. Through Tuesday, I believe, the following Tuesday.
And what about the rest of the time that you were in California? Do you recall any conversations that took place about Watergate that you have any knowledge of?
No, sir. At no time was I ever included in any of those conversations with any of those people.
While you were in California, did you make any phone calls back to Washington?
I have been asked, I believe, that question by one of the members of your committee. I received a phone call from the same Roger Stone who I mentioned earlier in about my earlier testimony. And Mr. Stone was taking care of our house while we were gone. I had taken my family out to California for the summer.
Well, was this
He was, yes, sir, it's significant. He was, I think it was on Monday night, I guess feeding our dogs, and the phone rang, and a voice asked for me, and he said, is Bart Porter there? And Mr. Stone said, no, he wasn't. And he said, who's this? And the voice said that, it sounded like an older man, according to Roger. It said that this is Jim McCord. And Roger said, I don't believe you. And I guess the man pressed him and said, yes, it was. He said, where are you? And he said, well, I'm in jail. I want to talk to Porter. I don't think this is accurate. I think it was personally a hoax or some friend calling. But anyway, Roger called me in California immediately, and I was convinced it was a prank because I hardly knew Mr. McCord, and he would have no reason to call me. But because Mr. Magruder, I think I tried to get to Mr. Magruder, I'm not sure, but I did call Mr. LaRue. I felt somebody should know that I had received that call, and so I think I called Mr. LaRue and told him that, and he just took the information and said thank you, and that was the last I heard of it.
Now, when you returned to Washington, again, did you participate in any conferences, phone conversations with anyone about this Watergate break-in?
No, sir, not at all.
Did you hear anybody discuss it there at the committee to re-elect the president?
No, sir.
What about destruction of records? What records have you destroyed other than the accounting that you mentioned?
Well, I really didn't have any other records, Senator, other than some speech material and some travel schedules that were out of date, and other things that I had been kind of saving over a period of months that really were not, I wouldn't classify as anything important, nor I did have those, and I did throw those away, I think.
From the time that you were in the service of the committee to re-elect the president till now, have you ever had any discussions about Watergate or bugging or surveillance or sabotage with Mr. Haldeman?
Never.
With Mr. Ehrlichman?
Never.
With Mr. Dean?
Never.
With Mr. Colson?
Never.
With Mr. Kalmbach?
Never.
With Mr. Mitchell?
Never.
With anyone whose name I have not mentioned?
With anyone whose name you have not mentioned?
That's right.
Mr. Magruder,
aside from Mr. Magruder that we've heard about.
Yes, sir. I don't believe so, sir.
I understand.
I don't think so.
I understand you had a meeting on January 24, 1972 with Mr. Mitchell and Mr. Magruder. Is that
That's correct.
fact? What was the substance of that meeting?
The substance of that meeting was that many of us who had come on early in the campaign had been preparing a series of position papers and other reports on various aspects of the campaign. And although I was supposedly the director of scheduling, I had a few other duties that I had to perform, like putting together an ethnic report, a Middle American vote report, a Spanish-speaking, Spanish-American voter
these were
report.
routine
Yes, sir.
campaigns.
These were large documents, and Mr. Magruder set up a meeting on the 24th for me to deliver these reports to Mr. Mitchell. And
nothing occurred in this meeting about bugging, surveillance,
no, sir,
sabotage?
not at all.
Just two final questions. Do you know of your own knowledge whether the President of the United States had any prior knowledge about Watergate?
No, sir, I do not.
Surveillance?
No, sir, I do not.
Do you know of your own knowledge whether the President of the United States had any participation or knowledge of the cover-up?
No, sir, I do not.
Do you yourself have any knowledge of the cover-up?
Only
other than what you and Mr.
No,
Magruder
sir,
discussed?
only the extent of my own involvement, and that's where it ends.
Thank you. That's all, Mr. Chairman.
Yes, sir.
Some Talmadge.
Porter, what was your position before assuming your post with the committee to re-elect the president?
Sir, I was a staff assistant to the president working in Mr. Herbert Crijns' office at the White House, principally in the same area, Senator Talmadge, in the Speaker's Bureau, responding to requests for speakers that would come in to the executive offices.
Who offered you that position?
I'm sorry, sir.
Who offered you that position?
I believe Mr. Magruder did back in January of 1971.
Now, why were you upset when Mr. Magruder suggested that the committee to re-elect the president files and records might be searched?
Well, sir, we had an extensive, as I understood it, an extensive advertising plan. We had our key state. That was quite a confidential plan of what states we were targeting, the amounts of money we were going to spend in each state, all the polling data we had, the research data we had, the plans for the telephone banks that ultimately were quite successful that we had. I mean, all those things. My whole surrogate planning schedule for the campaign. These were things that I understood could all be subpoenaed and made public.
You know of nothing illegal that was in the files?
No, sir, I do not.
That you do,
no, sir, I do not.
Excuse me, go ahead.
Yes, sir, I'm sorry.
The only thing you were concerned about was political information of a sensitive nature. Is that an accurate statement?
That's an accurate statement.
Did Mr. Magruder ever mention the president's name to you when he discussed with you this Watergate matter?
The president's name was mentioned, sir, in the context of save the president from embarrassment, doing this for the president. He never did he imply, nor did I infer, that the president of the United States was aware of Mr. Magruder's request of me. No, sir.
Did he indicate to you that it is important to keep the investigators from getting to Mr. Mitchell, Mr. Haldeman, and the president?
No, sir. I think to answer the question directly, the answer would be no. However, Mr. Magruder did say, I believe, that it was important that the investigation be kept to the Watergate investigation and avoid the embarrassment that could be caused by having it go on to other areas. And he specifically mentioned Mr. Haldeman, Mr. Mitchell, and the president as being those, and I think those are the three he mentioned, that could be embarrassed.
Did he wanted the information to investigators to be kept from the president, Mr. Mitchell, and Mr. Haldeman? Is that your testimony?
Mr. Magruder didn't key on the investigators as much as he did the opposition, the Democrats coming in.
What was the area of sensitivity there? Why did he mention those specific names?
I don't know, sir.
Did Magruder tell you that he'd talked with Mr. Mitchell about this matter?
Yes, sir.
What did he say Mr. Mitchell said?
He did not, sir. He said that as I have stated earlier, that he had come from a meeting where my name had been brought up, and in that context, he mentioned Mr. Mitchell's name.
What did he say Mr. Mitchell said?
He did not quote Mr. Mitchell directly.
Didn't say anything in that regard?
I think to answer that question would mean that I should say that Mr. Magruder, in stating those who were present at the meeting, I got a picture that there was a discussion of me and that he was bringing the message from the meeting. So in that context...
what was the nature of the meeting? What was it about?
I do not know, sir.
What did Mr. Magruder tell you occurred at the meeting?
Mr. Magruder said that my name had come up and that there was, first of all, he said he wanted to assure me that no one higher than Mr. Liddy was involved in the Watergate. However, there was a problem with the authorized funds given to Mr. Liddy, and that apparently he had taken some of these authorized funds that had been authorized for what Mr. Magruder claimed to be legal purposes, but embarrassing purposes.
Well, how did your name arise in the conversation?
Well, Senator, they apparently had decided at this meeting that they wanted to be able to say or tell the investigators that the money had been authorized to Mr. Liddy for something, I believe my words the other day were a little bit more legitimate sounding than what they had been authorized for. And and Mr. Magruder was going to do that and asked me, and I got the impression that I was being asked by the others also, to corroborate that story and to, in fact, replace one lawful authorization with another, one that would be less embarrassing, but one that was not in any way, in my opinion, and to my knowledge at the time, tied in any way to Watergate.
As I recall, you testified last week that Mr. Magruder urged you to commit perjury, did you not?
I didn't use those words, Senator.
That was the sum and substance of it, wasn't it?
Mr. Magruder asked me to corroborate and change the date of a conversation.
Did he say he was making that statement on his own initiative or authority, or that it came from higher levels?
I don't believe that those words were used, but I certainly got the impression that they were from a group of people, not just Mr. Magruder.
What group do you think it was?
The group that he said was at the meeting, which was
Who was
Mr. Mitchell, Mr. LaRue, Mr. Magruder, and a fourth person whose name I have not been able to remember for a year.
You think that was the group that urged you to follow the Magruder pattern? Is that the idea?
Yes, sir, it is.
All right. Now, did Mr. Liddy ever give you some sealed envelopes?
Yes, he did.
How many times?
I would say 3 to 4 times.
What was his instructions when he gave you those envelopes?
Mr. Liddy asked me to hold them for him, and with the instruction that if anything should happen to him, that I should take those envelopes directly to the Attorney General.
And who was the Attorney General at the time?
Mr. Mitchell.
Did he tell you what the contents of those
No,
sealed
sir, he did
envelopes
not. They were sealed.
Were you curious about what they were?
I suppose
Did you have
retrospect, my curiosity was piqued somewhat, but not enough to...
Did you have any impression at the time as to what those contents might be?
No, sir, I did not.
Did you ever wonder about the nature of it? Did he
think
give you
I
sealed
probably-
envelopes?
Surely, Senator.
Urge you that if anything happened to you, to give them to the Attorney General of the United
I'm
States?
sorry, sir, I missed the last question.
Did it excite curiosity in your mind that he would give you sealed envelopes and tell you, instruct you, that if anything happened to him, you would deliver them to the Attorney General of the United States?
Yes, sir, I'm only human. I was naturally curious, but as I say, they were in my safe, and I forgot about them most of the time, quite frankly.
Did you return them to Mr. Liddy after he came
No,
back?
sir. Mr. Liddy asked me on one occasion to shred them. He said, you know those envelopes I gave you, go ahead and shred them.
And you would do so?
I did.
All 3 times?
Sir, no, I mean all at once. I believe the 4 envelopes that I had, 3 or 4 envelopes I had.
You shredded them at one time and not after he returned? And
Oh, no, sir, no. I shredded them all at one time.
One at a time. Now, you testified last week about a meeting you had with Mr. Parkinson, whom I believe was a lawyer for the re-election of the president, was he not?
I'm not sure exactly which committee Mr. Parkinson represented, Senator, whether it was the Finance Committee or the Re-election Committee, but...
At that time, I believe he directed you or suggested to you that you play ball by Magruder's rules, or what was the comment that he made at that time?
No, sir, I believe the conversation you're referring to, perhaps that the staff has put down, is that during the May 28th meeting that I had with Mr. Parkinson in his office at his request, Mr. Parkinson made a comment about me by Mr. Magruder. And I don't remember exactly what the comment was, but I said, well, that's kind of a strange thing for him to say or something. And he said, well, let me tell you exactly what he said. And he picked up a yellow notepad, and he had on it notes that he said he had taken from an earlier conversation with Mr. Magruder in his office. And he read from the bottom part of the page, and I quote him, Porter told to play ball by Mitchell, LaRue, Dean, and Magruder. Porter will not hold up under indictment. Then he flipped the page, and it said, Porter had meetings with Mitchell, Dean, LaRue, Magruder. And I looked at him rather incredulously, I think, and I said, well, first of all, Ken, I was never told to play ball by anybody. I never had a conversation with Mr. Mitchell or Mr. LaRue or Mr. Dean, but Mr. Magruder was the only one that I talked to. that the expression play ball was certainly never used, and I described to him again the conversation that Mr. Magruder had with me. Turning to the second paragraph, I never had any meetings after that with Mr. Mitchell or Mr. Dean. I may have had conversations with Mr. LaRue, but I wouldn't classify them as meetings. That was the extent of it.
Did anything else of significance occur at that conversation?
I believe I've already testified that Mr. Parkinson told me when I detailed my story to him that I had no problem, that I had not committed perjury, that I had embellished a story, that I shouldn't worry about it. And when I asked him if he thought it wise for me to get a lawyer or in this thing at all, he said no. I was certainly entitled to do so, but he thought that would be a little disruptive at that point, and it would take too long for a new lawyer to come in and learn all the facts in the case. And we were referring now to the civil suit filed by the Democrats in which I was named as a defendant. And so I took that advice and left.
Thank you, Mr. Porter. Thank you, Mr. Chairman. No further questions.
Senator Wycliffe.
Mr. Porter, I'd just like to cover two areas. First of all, in disbursement of the monies, the list of which you gave to Senator Gurney, did you mention in that list the purchase of microfilm viewing equipment?
No, sir, I did not. And that should be in there.
You did not mention it in the list which you gave to Senator Gurney?
No, sir. I probably, in my own mind, I had that classified under the REITs, under the REITs money, but I did not specifically mention it.
Well, is it REITs money, or is there a separate expenditure there?
It is a separate expenditure, Senator.
Then could you give me the amount of that expenditure?
I believe it was probably $60, $50 or $60, something like that.
In the nature of microfilm viewing equipment?
Yes, sir. Well, I wouldn't classify it as microfilm viewing equipment. I would classify it as a film strip viewing equipment, 35 millimeter film strip, not microfilm.
Now, you say you thought you had this classified in your mind under the REITs payments, but isn't it so that you gave this money to your secretary, Martha Duncan?
No, sir. Don't believe so.
You gave no money then to your secretary to purchase microfilm viewing equipment?
No, sir, I don't believe so. I did not. If you'd like me to tell you what I know about buying any equipment, I certainly can, but I don't remember giving Mrs. Duncan or Miss Duncan. At least nothing was ever purchased as a result of it.
You never instructed your secretary to purchase viewing equipment for microfilms?
Senator, I don't remember. I think at the time that Mr. Magruder brought some 35 millimeter negative film to me on occasion, I remember looking for a better viewing vehicle than a little tiny thing that you had to hold up to your eye. And I did go, I believe, to one or two camera stores around close to the committee and look for a 35 millimeter film strip projector. Now, it's possible that I might have asked Miss Duncan on a lunch hour or something to go to one of these places to see if she could find one or see if she knew where I could get one. I was having trouble finding one, and I ended up getting one in New York, or out of a New York company. So Miss Duncan did not purchase any of that equipment, to my knowledge.
What was the purpose of this equipment?
The purpose of the equipment was to view 35 millimeter film strips that were given to me.
And what was the nature of those film strips?
The nature of the film strips were that they were appeared to be 35 millimeter photographs or negatives of intra-office memos from Senator Muskie's campaign headquarters to his Senate offices and back again.
And did you give any sort of an admonition to your secretary, Ms. Duncan, as to whether or not she was free to talk about these matters?
I think there was a general understanding, Senator, at the time that it wasn't anything you went to a party and talked about, if that's an answer to the question.
Well, I want to know exactly what Mrs. Duncan's function was in relation to these particular microphones.
Well, let me back up, Senator, to answer the question, I think, a little more fully and put it in context. At a certain time, and I don't remember the exact month, November perhaps of 1971, Mr. Magruder came into my office with a small roll, very small roll of 35 millimeter film strip and a little viewing device that had a little light source from the back. And he said, "Here, hold these for me." Put them in my safe or desk or whatever I had at the time. I asked him what they were, and he said, "Well, you can look at them, but never mind." So I looked at them, and they were apparently, as I say, inter-office memos from staff members in Senator Muskie's office. He came back later, I think a day later perhaps, and retrieved the film strips, took them, and said that he was going to show them to Mr. Mitchell. He came back, and apparently he did show them to Mr. Mitchell because he was a little irate at me for not making sure that the batteries worked. And apparently he got all the way to Mr. Mitchell's office and the batteries didn't work, and he blamed it on me. But anyway, after that time, and he gave the film strips back to me, I would say there were probably 4 or 5 frames on the strip. I think I asked Mr. Magruder where he got them, and he refused to tell me at that time. At a later date, Mr. Magruder said that Mr. Ken Reitz was going to deliver these film strips to me, and would I view them and for him, for Mr. Magruder, and anything that I thought was, quote, important or interesting, that I should bring to Mr. Magruder's attention, and he would then tell me what to do with it. I did that, and Mr. Reitz started delivering these things to me, and I did view them, and I think the first or second time that I did this, it became apparent that I needed something a little more easy on the eye, perhaps, to see what these things said, and so I then went out and out of my own pocket, I think, wrote a check for just a small little projection device so that you could see it, you could enlarge it and see what it said.
All right, now, that's, let's take it right at that point. Did your secretary participate in typing any transcripts or memorandum based on these microfilms?
Yes, sir. She did. On one occasion, I remember there was I think it was in December, early December, there was a staff memo that I saw from one of the campaign officials to the senator, or perhaps to his campaign manager, saying that the senator's role, I believe, as chairman of a subcommittee on governmental operations or something like that.
Which senator is this?
Senator Muskie.
Senator Muskie.
Could be used as a great front to go to California and hold tax hearings. That would be a great visual event for Senator Muskie and all at the taxpayer's expense, and could get a lot of value for his campaign. We thought that was rather interesting, to say the least, and I told Mr. Magruder about it, and he asked me to just copy the memo on I believe it was written on plain bond, and send it to Evans and Novak. Miss Duncan did that. Miss Duncan typed it, and we sent it to Evans and Novak, and they printed it, and the hearings were never held.
All right. Were there other documents or other instances where Miss Duncan performed services relative to...
Yes, sir. I believe it was Miss Duncan. On one occasion, Senator Muskie's speech that he was going to deliver in the Senate against the nomination of William Rehnquist to the Supreme Court was on the film, and I specifically, it was about 20 pages, and I asked Mr. Magruder what he wanted me to do with it, and he said, let me check. And he did check, and he got back to me and said, Mr. Mitchell would like to see it. And so that had to be completely typed, and I had to I read off the film into an IBM dictaphone, and I believe it was Miss Duncan who typed that. I believe it was she.
Miss Duncan now being your secretary,
yes,
is that correct?
Yes, sir.
At any time did you send Miss Duncan to the White House to give Gordon Strawn copies of the photograph documents or the transcripts emanating from those documents?
I don't remember, sir, whether I did or not. I do not remember. It's possible that I did. If I did, it would have been because Mr. Magruder would have said, take a copy of this over to Gordon Strawn.
I want you to be. I do want you to think about this answer.
I understand, and I think I do remember.
I'm not trying to mislead you on it, and if you care to take a minute here or so, just to carefully think about, please do so. I don't want to rush you.
I think I will tell it as I remember it, and I do. Let me say this: certainly, if Miss Duncan says that happened, then it did happen. I will not dispute anything that she might say. On the other hand, the only reason that I would send a document over to Mr. Strawn would be at Mr. Magruder's suggestion or direction. I believe that I do remember sending. I believe there was only one copy of the Rehnquist speech put together. I think it was so long. However, on the item that appeared that was sent to Evans and Novak, I think perhaps that may have been sent over to Mr. Strawn. I just don't remember, Senator.
And you realized at that time that these various documents, let me rephrase my question. The obtaining of these documents, did you consider them to have been obtained legally or illegally?
I remember asking Mr. Reitz, the first question I asked him, I said, is this any part of the U.S. mail? And he said no. I knew that intercepting the U.S. mail would be a violation of the law. I put the photographing of a document in the same category as Xeroxing a document. If you're taking a picture of it one way, you're taking a picture of it another way. So I did not think it was illegal. I thought it was very surreptitious, but I did not think it was illegal.
Thought it was surreptitious?
Yes, sir.
But you didn't think that it was illegal?
No, sir.
Why then did you indicate to your secretary that these were not matters to be discussed?
I think that's, in my opinion, that would be self-evident, Senator Weicker, that you wouldn't go around discussing things like that, the same as you wouldn't go around discussing any kind of information gathering that you might be doing.
Did you indicate to her that if she discussed it, she'd be fired?
I don't believe I've ever made that statement to her, no, sir.
Again, let me just ask the question. Am I correct in paraphrasing your answer to me that there might have been an instance where you sent material to the White House, to Gordon Strachan, or am I correct in saying that there were those instances, and if so, how many? That's my question.
I cannot remember the exact number of instances that I sent things to Mr. Strachan. Mr. Strachan would get copies addressed to Mr. Haldeman of many things that I did, Senator, in relationship to my primary function at the campaign of the surrogate operation, and schedules and plans.
No, I understand that, but
I don't remember. Excuse me.
Excuse me.
Well, I just don't remember specific instances where Mr. Strachan was sent an item here, an item there. As I say, if Ms. Duncan says that she did, then I would believe that. But I personally don't remember that specific instance.
You do not remember, then, sending Ms. Duncan to the White House to give Gordon Strachan copies of these photographed documents?
I would say that if it's an answer, I kind of remember it, but not enough to sit and testify that I did it. All right. I mean, I sent Mr. Strachan documents, and on occasion Ms. Duncan would hand carry them for one reason or another, either because the messenger wasn't going to come back till 4 o'clock and it was noon, or Mr. Magruder wanted to get something over there right away, or something like that, and the secretaries would hand carry them.
I have no further questions, Mr. Chairman.
Yeah.
So in the first hour of testimony, Mr. Porter has given us far more information than we had before about the extent of the espionage on Senator Muskie's campaign. That staff memos in his campaign were photographed and copied by Mr. Porter and may have been forwarded to the White House. In a moment, he'll be asked about documents that he destroyed after the Watergate break-in. We'd just like to say, while we take a pause, that we are very gratified with the viewer response to this gavel-to-gavel experimental coverage of the Watergate hearings on public television. The response has been enormous in the mail, and if any of you still want to express an opinion about it, we suggest that you do it to your local public television station, the station you're watching now. After all, it is that station which depends on your support, and which, incidentally, in the public television system, actually makes the individual decision on whether to carry programs of this kind. Public television's coverage of the hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As the hearings resume, hour number 2 will include more questions put to Herbert Porter and some praise for his testimony. and that involves some of Senator Ervin's now famous use of Shakespearean quotations to characterize witnesses.
And to Montoya.
Mr. Porter, I believe at one stage of your testimony you stated that you had been instructed by Mr. LaRue, Mr. Magruder, Mr. Parkinson, and Mr. O'Brien not to mention Mr. Reasoner in your testimony.
Yes, sir. I think, again, I'm not sure that I stated it exactly that way. I think what I stated was that Mr. Magruder specifically asked me not to bring up Mr. Reasoner's name to the FBI or to the grand jury. Mr. Parkinson...
Did you ask him for any reasons why?
I believe I asked Mr. Magruder why, and he said, Bob's not involved in any of this. He's a young guy. Why don't you leave him? You know, it doesn't do any good to drag his name into it. Words to that effect. Those were the same words I think that Mr. Parkinson used. Oh, you know, he's a younger fellow, and he doesn't need to be dragged into this thing.
Well,
you don't have to mention his name, don't mention it.
Did you know at the time that he might or could have been involved?
No, sir, I did not.
Mm-hmm. What was Mr. Reasoner's capacity or position in the CRP at that time?
Mr. Reasoner was Mr. Magruder's administrative assistant.
And pursuant to your conversation with Mr. Parkinson and the other people, you did appear before the FBI, or you were interviewed by the FBI. You did appear before the grand jury, and you did appear before the U.S. attorney, did you not?
I did appear before the FBI. They did interview me. I did appear before the grand jury on one occasion, and I did appear at the trial of Mr. Liddy and Mr. McCord.
And the testimony which you had used at all three places was with respect to the disbursement of approximately $100,000?
No, sir. That's not correct.
What was your testimony?
My testimony was that I gave Mr. Liddy approximately $30,000 to $35,000, which is correct. What I stated that was not correct was that Mr. Magruder had asked me in December how much a program of infiltrating radical organizations would cost, and I told him that it might cost $100,000. Mr. Magruder, I understand, used that as a basis, that conversation as a basis to then say that he had authorized Mr. Liddy $100,000 for the infiltration of radical groups so that he wouldn't have to say that he gave authorized $100,000 to Mr. Liddy for dirty tricks.
Well, there was There was a dialogue between you and Mr. Magruder with respect to the figures about which you would testify before the grand jury, namely $100,000 or $80,000. Was there not?
No, Senator. I think what you're referring to is that the $100,000 figure that I testified to was a hypothetical figure. I never testified.
I understand that, Mr. Porter. You mentioned this in a conversation with Mr. Magruder, indicating to him that he could justify the expenditure of $100,000 by hiring 10 students.
Yes, sir.
But what figure did
As the hearings resume, hour number 2 will include more questions put to Herbert Porter and some praise for his testimony. And that involves some of Senator Ervin's now famous use of Shakespearean quotations to characterize witnesses.
Then to Montoya.
Well, Mr. Porter, I believe at one stage of your testimony you stated that you had been instructed by Mr. LaRue, Mr. Magruder, Mr. Parkinson, and Mr. O'Brien not to mention Mr. Reasoner in your testimony.
Yes, sir. I think, again, I'm not sure that I stated it exactly that way. I think what I stated was that Mr. Magruder specifically asked me not to bring up Mr. Reasoner's name to the FBI or to the grand jury. Mr. Parkinson...
Did you ask him for any reasons why?
I believe I asked Mr. Magruder why, and he said, Bob's not involved in any of this. He's a young guy. I wanted to leave him. You know, it doesn't do any good to drag his name into it. Words to that effect. Those were the same words I think that Mr. Parkinson used. Oh, you know, he's a younger fellow, and he doesn't need to be dragged into this thing.
Well,
you don't have to mention his name, don't mention it.
Did you know at the time that he might or could have been involved?
No, sir, I did not.
Mm-hmm. What was Mr. Reasoner's capacity or position in the CRP at that time?
Mr. Reasoner was Mr. Magruder's administrative assistant.
And pursuant to your conversation with Mr. Parkinson and the other people, you did appear before the FBI, or you were interviewed by the FBI. You did appear before the grand jury, and you did appear before the U.S. attorney, did you not?
I did appear before the FBI. They did interview me. I did appear before the grand jury on one occasion, and I did appear at the trial of Mr. Liddy and Mr. McCord.
And the testimony which you had used at all three places was with respect to the disbursement of approximately $100,000?
No, sir. That's not correct.
What was your testimony?
My testimony was that I gave Mr. Liddy approximately $30,000 to $35,000, which is correct. What I stated that was not correct was that Mr. Magruder had asked me in December how much a program of infiltrating radical organizations would cost, and I told him that it might cost $100,000. Mr. Magruder, I understand, used that as a basis, that conversation as a basis to then say that he had authorized Mr. Liddy $100,000 for the infiltration of radical groups so that he wouldn't have to say that he gave authorized $100,000 to Mr. Liddy for dirty tricks.
Well, there was there was a dialogue between you and Mr. Magruder with respect to the figures about which you would testify before the grand jury, namely $100,000 or $80,000. Was there not?
No, Senator. I think what you're referring to is that the $100,000 figure that I testified to was a hypothetical figure. I never testified.
Yes, I understand that, Mr. Porter. You mentioned this in a conversation with Mr. Magruder, indicating to him that he could justify the expenditure of $100,000 by hiring 10 students.
Yes, sir.
But what figure did you testify to before the grand jury and at the trial?
Which figure are you referring to, Senator Montoya? I'm not. The money I gave to Mr. Liddy, or the money that?
That is correct.
I testified at the FBI and to the grand jury and to the trial that I gave Mr. Liddy a total pre-April 7th of approximately $35,000.
Where did the $100,000 enter into other than, as you have mentioned, with respect to the illustrative case that you have referred to?
It did not.
All right. Now, when you went to Mr. Parkinson's office, did he at any time indicate to you that Mr. Magruder was going to contend that there had been a delivery of $100,000 to Mr. Liddy?
No, sir.
Now, did you at any time visit Mr. Silbert?
I have visited Mr. Silbert recently, sir.
Did you, during those days when you were conversing with Mr. Magruder about a possible appearance that he might make at Mr. Silbert's office, did you at that time visit Mr. Silbert?
No, I did not, sir.
Did you ask Mr. Magruder or Mr. LaRue for a government job during your discussions with them about your grand jury testimony?
To answer that question specifically, I would have to answer no, but there's some yes in it, and if I could perhaps explain that. In January of this year, when we were getting through with the President's inauguration, obviously the thoughts turned to future employment. And I got, Mr. Magruder told me that I believe it was Mr. Malik at the White House could possibly be an obstruction to my getting a good job with the government, and I asked Mr. Magruder what he thought I should do about it, and he said, I think Mr. Mitchell could probably help you a little bit. He's, still got some clout there, and so I said, well, what's the best way to do that? Should I call him directly or what? And he said, no, why don't you talk to Fred LaRue? So I believe I went over and talked to Mr. LaRue, and the conversation went something like my saying, Fred, the problem that I have with Mr. Malik, I said, I have been a pretty loyal guy, and he said, yes, I know that, and I said, I don't want to be treated any better than anybody else, but I sure as heck don't want to be treated any worse than anybody else either. And do you think that Mr. Mitchell could perhaps make a call and unloose the logjam a little bit? And he said, yes, I'll call him. And I understand that he did. That was the extent of that conversation.
Why were you concerned about Mr. Malik obstructing any move that you might make?
Mr. Malik was in charge of handing out government jobs, Senator, and it didn't sound too good when I heard that he perhaps could be an obstruction to my getting one. And
what reason did you have to believe that?
Well, I think it was strictly personal, Senator.
Was it
between Mr. Malik and me.
Was it your understanding around the CRP that on important decisions that Mr. Haldeman should be informed?
Yes, sir.
And what sphere of decisions would you say covered any communications between the CRP and Mr. Haldeman at the White House?
Senator, I can only, I would have to confine my answer to my area of involvement in the surrogate scheduling program, but everything that I did, all reports, all plans, all schedules, all states, key states, times, etc., were all sent to Mr. Haldeman. And
would that include disbursements?
Sir, I'm not aware of that. I was never asked to give Mr. Haldeman or anybody like that any...
Well, would you say definitely that it did not include disbursements?
I would say that to my knowledge, it did not include any of the disbursements that I made, but that's as far as I could go.
And you mentioned that for every disbursement which you made, you had received a receipt.
Yes, sir.
From the recipient.
Yes, sir.
And how long did you keep these receipts?
The initial receipts from the pre-April 7th money I kept until the end of March, I believe, when Mr. Sloan asked me to balance with him. I did. The figure was approximately $52,000. I had balanced. I had no reason to keep the receipts any longer. Excuse me. And so I threw them away. I had additional receipts that were in my possession until after the Watergate break-in, and I would say approximately a week or 10 days after the break-in, I believe it was Mr. LaRue came by my office and said, you know, if you have anything that might be politically sensitive or whatever, again, using the immediate discovery story, the Democrat civil suit, you know, why don't you just throw it away? And so I kind of went through a few things, and I didn't think I had anything politically sensitive, but in that same process, I did ask Mr. Reesner to come in again. We did balance, and Mr. Reesner was made aware of the money and the cash on hand and the amount of money received from Mr. Sloan, et cetera, and those receipts then were thrown away.
Who did you show these receipts to before you destroyed them?
Mr. Reesner.
Did you show these receipts to Mr. Magruder?
I don't believe so, but it's my understanding that Mr. Reesner relayed the information to Mr. Magruder. At least that's what he has told me.
And what was so sensitive with respect to Watergate and these receipts that you, in your own discretion, destroyed them?
No, sir, I never said there was any relation to Watergate at all. And I don't put anything in the category that I relayed to you involving any of the payments that I made after April 7th to Watergate.
Well, just mention or state to me what sensitivity did you find in those receipts that warranted their destruction?
Yes, sir. Well, as I say, Mr. LaRue had come to my office and had asked me to throw away anything that could be in the category of being politically sensitive. I put in that category payments to Mr. Odell during the mining of the Haiphong Harbor, and payments to Mr. Joannou, which I later learned was for an ad in the New York Times. I felt that those were politically sensitive enough that I should not keep them.
Well, what others?
Well, sir, if I was going to throw away 2 or 3, I just took them all through. Again, I had balanced with Mr. Reesner and had no need to keep them.
Well,
in other words, it was strictly in a...
You must be able to recall other instances and the sensitivity
no, sir, I do not.
That you placed on those receipts?
No, sir, I do not. As I have stated, I had balanced with Mr. Reesner. I did not have an accounting function at the committee. The receipts were strictly internal documents. They were not meant for any public viewing at all, and they were strictly internal, and I had satisfied the internal requirement, and I destroyed them. I threw them away.
All right. How many receipts would you say that you destroyed? Can you estimate
that? The second time, sir? After the Watergate break-in? I would say approximately 10.
And did you destroy other documents?
I had some, as I say, travel schedules and old speeches and position papers and that sort of thing from some of the potential candidates that I had been keeping that I threw away.
Now, what were your exact duties at the CRP besides scheduling? What other duties did you have?
Well, sir, as I said in one of my earlier statements, almost all of my time was spent in the surrogate scheduling, planning for the surrogate program, which amounted to over 1,000 man-days of campaigning on the part of the surrogates, all their schedules, talking with state chairmen and their appointed agents all over the country, working on airline schedules.
Mr. Porter, I don't mean any duties pertaining to your scheduling and being out in the field. I say within the CRP, in-house, what other duties did you perform?
Other than those that I've described, sir, that was it.
In other words, you were the one who would give instructions to Mr. Sloan for the disbursement of money.
Beg your pardon, sir?
You were the one that would give instructions to Mr. Sloan for the disbursement of money, or you would receive the money from Mr. Sloan and in turn give money to individuals such as Mr. Liddy.
That's right. I received my instructions from Mr. Magruder on who was to get certain funds and approximately how much. And I did go to Mr. Sloan, and I did get those funds, and I did pass them on to various individuals. As I stated to Senator Baker, I believe, on Thursday, of the some $69,000 that went through me from Sloan to others, that in going back about 75% of that, I did not know what the money was being used for at the time. I served as I guess more or less a bank teller, really, or a messenger to go down and pick it up.
That's all, Mr. Chairman.
I have just one or two questions.
Yes, sir.
Mr. Porter, you give the appearance of a man who's brought up in a good home.
Thank you, sir.
And you were undoubtedly taught that it's an obligation of a citizen to testify truthfully when he's called on to testify on oath before a grand jury or a petty jury.
Yes, sir.
But you were persuaded not to do so with respect to the non-existent conversation between you and Magruder in December 1971 by Magruder's insistence that your loyalty to the president required you to go along with him on that proposition?
I would say that's basically...
And then later you applied for a position with the government and did not receive it.
I would say a more accurate response to that is that I encountered quite a bit of difficulty in getting it, and finally did receive an offer which I received on my own initiative.
Yes. Well, it was a wise man...
I'm sorry, Mr. Chairman, and rejected it.
Yes. There was a wise man named William Shakespeare that wrote a play called Henry IV. And in that he has one of his characters, Cardinal Wolsey, say, after Cardinal Wolsey, instead of serving the church, had served his king, and he was cast out in his old age with the king, and he said, had I but served my God with half the zeal I served my king, he would not, in mine age, left me naked to mine enemies. You have some questions. You have a question. Please cut out the applause. Something's bacon.
Mr. Chairman, I have no further questions. I thank Mr. Porter for long, arduous testimony. He's been here now for the better part of 2 days. We've covered a lot of material. Very frankly, there's a lot more material to cover. As Mr. Porter will recall, when I first examined him, I asked him if he was prepared to return and ask other questions on other subjects, and you indicated that you were. In the interest of time and orderliness, the committee has tried in an informal way to compartmentalize these proceedings to particular subject matters. So we've omitted to ask certain questions. We have not probed in great depth into other matters, but we intend to do that, and I understand you are fully agreeable to returning to testify. Thank you very much, Mr. Porter.
Counsel have some concluding questions.
I have 2 or 3 questions along the lines we've been talking about, Mr. Porter. First, did you ever meet privately with any assistant U.S. attorneys before your grand jury appearance that led to the September indictments?
No, sir, I did not.
Now, in your conversations with...
That's correct, I did not.
Now, in your interview with the Federal Bureau of Investigation or your testimony before the grand jury, were you ever asked for example, the sums of money, the denominations of money which you gave to Mr. Liddy?
Yes, sir.
And what did you say?
The same thing I've stated to this committee. The sums were, the total amount, aggregate, was approximately $32,000, and the individual amounts ranged anywhere from, I think, $500 to, on one occasion, $6,000.
Were you ever asked, in view of the fact that the program required setting up of 10 individuals at $1,000 a month, why the units you gave Mr. Liddy were not in units of $1,000 or aggregated $10,000 a month?
No, sir, I don't believe so.
Was it your understanding that the conversation which you had with Mr. Magruder, according to your testimony,
yes, sir,
would provide the justification for your having paid Mr. Liddy the sum of $30,000 or so?
Mr. Dorson, I never testified. In fact, let me state it positively. I testified that I did not know specifically what Mr. Liddy did with the money I gave him. I also testified that I gave him a total of approximately $35,000.
But am I correct that your supposed conversation with Mr. Magruder, the one that never took place,
yes, sir,
was supposed to provide a justification for the large sums of money given by you to Mr. Liddy. Is that correct?
It's my understanding that part of the money that I gave to Mr. Liddy was supposedly going to be justified under that basis, and that later I learned that there was a substantial sum that Mr. Sloan had given him, which I had not been aware of.
Were you asked by the FBI or before the grand jury any other questions concerning the use of the money you gave Mr. Liddy, such as whether you asked Mr. Liddy whether there were infiltrators, whether Mr. Liddy indicated there were infiltrators, or anything along those lines?
Not that I remember.
Now, Mr. Porter, you have stated today that at no time did you request immunity from the United States Attorney's Office, and in fact, I know that you have not requested immunity from this committee. Is that correct?
That is correct.
And I assume also that you have no desire to be indicted for perjury. Is that correct?
Yes, sir, that's correct.
And could you please tell the committee then why at no time did you or I assume your counsel seek immunity?
I guess, Mr. Dorson, that would really have to go, to answer that question fully, I would have to go back to Senator Baker's rather searching questions on Thursday. No matter how much a person prepares, he thinks he's prepared to answer a question like that, and then it turns out when he's faced with it, he fumbles a bit. And I have done a lot of reflecting on those questions and why I did what I did and why I'm here doing what I'm doing now. Many of the reasons the normal reasons that you read about in the newspaper and you hear about that people do things like that were not present in my case. I did not do it for money. I did not take a bribe. I didn't do it for power. I didn't do it for position. I didn't do it to hide anything I had done because I didn't think I had done anything. And yet, on the other hand, there were 3 or 4 factors that probably weighed, and I can't put any percentage on which weighed more or which toppled me over to the other side. My vanity was appealed to when I was told that my name had been brought up in high councils and that I was an honest man and made a good appearance and that sort of thing. My loyalty was appealed to the president. It was the heat of the campaign. A campaign, as I'm sure every one of you senators know, is an abnormal situation. You react, you act and react, and you spend most of your time reacting. And I think all of those things, coupled with what I have found now to be a weakness in my character, quite frankly, to succumb to that pressure, all added up to my tipping over to that side. Having discovered that weakness and having determined that the context in which what I did has been put, the first thing I told my attorney, I said, I want to go down and I want to tell the truth and I don't want to hide behind a darn thing. And I have not tried to make any deals with anybody. And as they say, I have not come to this committee to do so. Senator Baker used the word atonement the other day. Perhaps that's what I'm doing. I don't know. I let others judge that. But that's the way I feel, and that's what I'm doing.
I have no further questions, Mr. Chairman.
I have one question I'd like to put to the witness. From time to time, these people that you employed in the prank or sabotage department made reports to you, did they not?
On a couple of occasions, I believe they wrote letters and explaining what it was they had done. Yes, sir.
I'm not interested in the substance of the reports. Did they make reports to you by phone conversations?
The first gentleman, Mr. Greaves, talked to me a couple of times on the telephone. Yes, sir. And but he, as I say, he was only on board, so to speak, for a very short period of time, 2 weeks. So I don't believe there were any written reports at all, or any kind of. No reports were required. The second fellow, I believe, sent one handwritten statement that was later, I think, retyped and shown to Mr. Magruder, but it was brief, maybe about a page long, page and a half, and had to do with his activities in a field office of Senator Humphreys up in Pennsylvania someplace, or something like that.
Well, now, these reports, whatever nature they were, whether phone
say
calls
report, Senator.
or conversations, who did you report to about what they were doing?
Mr. Magruder.
Did you report to anyone else?
No, sir. Not
Did
to
you
my
report by written memorandum?
I believe on one occasion I did report on the, as I say, it was a narrative of the man's letter that he had sent on his activities in this field office in Pennsylvania.
Do you
that
know?
was the only one, as I remember.
Do you know if Mr. Magruder made a report to anyone about these activities?
I do not. I would expect that perhaps Mr. Magruder may have taken that document or that report and shown it to somebody.
But you and Mr. Magruder never discussed this? Whether he
No,
was...
sir, I don't think so. I think I gave it to Mr. Reasoner, as a matter of fact, and Mr. Reasoner had it and then gave it back to me.
This is the written report you're talking
Yes,
about?
sir.
Did Mr. Reasoner say what he did with it?
No, sir, he did not.
Did you make any reports at all to anyone in the White House during...
No, sir.
You did not?
No, sir.
Either during your term with the committee to re-elect the president or afterward?
Senator, on this particular subject matter or in all the things I was doing in my role as surrogate scheduler?
I'm not talking about the legal activities. I'm talking about Watergate, bugging, surveillance, sabotage, cover-up, all these activities.
Sir, I did not know anything about the Watergate. The only part of any so-called cover-up that I was aware of was the part that I knew about that I had said, and that was it, and I did not put that in the context of Watergate cover-up. But on any other things, there were no written reports to my knowledge at all.
Okay. Thank you, and thank you, Mr. Chairman.
I understand Senator Narwee has a question.
Thank you very much, Mr. Chairman. Mr. Porter, you've testified that you've been in charge of the scheduling of surrogate speakers. Did you schedule the appearance of the acting FBI director, Mr. Gray?
No, sir, I did not.
Who did?
Mr. Gray's activities or scheduling were handled out of the White House, it's my understanding. He was not a surrogate for the campaign.
Do you know who did the scheduling, sir?
I do not know firsthand. I have read in the newspaper reports that it was out of the White House Speakers Bureau.
Thank you very much. Thank you, Mr. Speaker.
The Bible bestows a blessing on him who sweareth to his own hurt and changeth not. I think you entitle that blessing. I want to commend you on the forthrightness of your testimony before this committee. Thank you very much.
Mr. Chairman, before the witness is dismissed, I want to join in that expression to the witness. I must say that he and I treaded on delicate and painful ground on Thursday. And I think you were very manly in the way you reacted to probing and searching questions. It's not an easy job you've undertaken, and the committee is not here to sit in judgment on your guilt or innocence. But the committee is privileged, I think, to comment on your forthcoming testimony and spirit. So while we have used your testimony to probe and explore the atmosphere of campaigning, I hope we have not left the impression that we have done so with an absence of sensibility for your own situation and your own private concerns. I think you're to be commended for appearing and testifying. The committee is grateful, and I am grateful.
Thank you, Senator.
Thank you very much.
Thank you, Mr. Chairman.
Your excuse now subject to recall at some future date if the committee desires.
Yes, sir.
Well, that completes the testimony of Herbert L. Porter, the last of the little fishes we're going to hear from for a while. Porter confessed on national television to having committed a crime. And on a very human level, you can't help but wonder at this point what's next in the life of Herbert L. Porter. Public television's uninterrupted coverage of the Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Well, we're still in the second hour, and the next witness is billed as the first star of this show, former Commerce Secretary Maurice Stans, who was finance chairman of the 1972 Nixon campaign. Stans is under indictment for his alleged involvement in the Vesco case, and he appeared with his attorney, Robert Barker, who immediately said, "No thanks, we'll pass."
I have been advised that one of the counsel for the witness desires to make some statement to the committee, and we'd be glad to hear you at this time. First, I would suggest the counsel identify himself for the purposes of the record.
Mr. Chairman, I'm Robert W. Barker, legal counsel for the Honorable Maurice H. Stans. Mr. Chairman and members of the committee, I appreciate this opportunity of making clear, for the record, Mr. Stans' legal position with respect to testifying before this committee at this time and under the prevailing circumstances. First, I'd like to clear up two items with respect to some of the confusion that may have arisen in the press. First, Mr. Stans has not requested and does not now request not to appear before this committee. He is merely requesting, Mr. Chairman, that in view of the impending criminal case in New York against him, that his appearance be deferred until an appropriate time. Secondly, no court has ruled or ordered Mr. Stans to appear and testify before this committee. In the criminal proceeding in New York, the judge has invoked the local court's Rule 8, which precludes the defendants or counsel discussing the controversy outside of the courtroom. Since this was made specifically applicable to Mr. Stans as one of the defendants, we applied to Judge Gaiardi for a ruling as to whether Rule 8 restrained Mr. Stans and counsel from appearing and testifying before this committee. We did not ask Judge Gaiardi to rule that Mr. Stans could not appear and testify. The court ruled that its Rule 8 did not apply to legislative hearings. It did not rule and reserved for a later ruling on whether the extensive blanket of publicity generated by the Watergate activities in this committee would impair the right of fair trial. He ruled that that would be considered at the time the trial is scheduled to commence on September 11th. Mr. Chairman, members of the committee, as you probably recognize, you have a very unique and unusual legal problem to face with Mr. Stans being called and subpoenaed to testify here today. He is the first witness to appear before your committee who is under an impending indictment for criminal matters arising out of the presidential election campaign. As was pointed out this morning by Judge Sirica in his ruling in the district court, the cases then before him did not involve people under pending indictments. He considered that an important distinction. The ruling which we will ask you to make is a very important and fundamental legal ruling. Since it involves Mr. Stans' personal and individual rights under the Constitution, it is much different than the position of the special prosecutor, Mr. Cox, when he asked merely that these hearings be deferred. Now, having said this, I'd like to take a minute to review some factual background upon which we will ask this committee to base its ruling. The first knowledge Mr. Stans had of the Watergate break-in was on June 18, 1972, when he read about it in the morning papers. He was just as shocked and just as surprised as any person in this room. Thereafter, consistent with his high standards of ethics and his position as a loyal American demonstrated by years of service to this country, he set a standard for himself and his staff, of complete cooperation with the investigation. When his legal counsel to the Finance Committee, Mr. G. Gordon Liddy, refused to cooperate with the FBI investigation, he was promptly discharged with Mr. Stans' approval. Immediately thereafter, Mr. Stans encouraged his own staff to cooperate, and he gave cooperation himself with all investigatory bodies and authorities. Commencing early in July of 1972, on 3 occasions, he voluntarily submitted himself to inquiries and discussions with FBI agents concerning the Watergate break-in and the presidential election campaign. On August 2, 1972, Mr. Stans voluntarily appeared and gave sworn testimony to the Assistant United States Attorney for use before the Watergate grand jury here in Washington, D.C. Subsequently, Mr. Stans voluntarily appeared before the staff of the House Banking and Currency Committee and gave information with respect to campaign finances and cooperated with that committee. On 6 different occasions, in addition to submitting the official reports required of the committee, Mr. Stans gave affidavits and discussed matters with representatives of the General Accounting Office concerning campaign finances and activities. He did everything he could to clarify matters. Again, voluntarily, he went to New York and appeared before the U.S. Attorney handling the grand jury investigation into the Vesco contribution to the campaign. And he then also voluntarily appeared on 2 occasions before that grand jury and fully and candidly and completely testified as to the matters known to him to the best of his ability. In addition, on 3 occasions, he has given depositions in the civil litigation arising out of the campaign. He's also testified for the litigation in Florida, a criminal case down there. Subsequently, he appeared before the staff of this committee and on 2 occasions gave them information concerning the campaign activities and finances. And he fully intended to appear voluntarily before this committee and to give it all the cooperation and assistance that he could. However, on May 10, the United States of America, of which the committee is part of a coordinate branch, changed the whole situation. It brought an indictment against Mr. Stans, charging him with very serious crimes arising out of the campaign and his duties as chairman of the Finance Committee. As you know, Mr. Stans pleaded innocent. Now Mr. Stans is before this committee under subpoena with the direction to testify about his function as chairman of the committee to re-elect the president. Inevitably, directly or indirectly, this hearing will influence any jury which might be called to hear the case in New York. This places Mr. Stans in an impossible position and a completely unfair one. Under our constitutional system and the fundamental laws of this land, an accused is entitled to a fair trial by an impartial jury, unimpeded by a deluge of publicity. In other words, as the Supreme Court said in Estes versus Texas, the concept of due process of law entitles the defendant to, and I quote, both judicial serenity and calm, end of quote. Now, Mr. Chairman, the inevitable clique light of publicity which will result from Mr. Stans' appearance here would preclude any judicial serenity and calm at the trial now set, as I say, for September 11 in New York. It would also tend to deny him the possibility of an impartial jury of the kind guaranteed by the Sixth Amendment. To paraphrase the language of the Supreme Court in Delaney versus United States, Mr. Stans' appearance before this committee and the television and other news media related thereto would accomplish additional investigation and extensive publicity, which would serve no other purpose than to further prejudice Mr. Stans' right to a fair trial. Now, the Supreme Court, in speaking of the problem of publicity and fair trial, has said, and I quote, "The court has insisted that no one be punished for a crime without a charge fairly made and fairly tried in a public tribunal, free of prejudice and passion, excitement and tyrannical power." Also, speaking of freedom of the press, the Supreme Court has said, "It must not be allowed to divert the trial from the very purpose of the court system, to adjudicate controversies both in the calmness and solemnity of the courtroom according to legal procedures. Among the legal procedures is the requirement that the jury's verdict be based on evidence received in open court, not from outside sources." The undeviating rule of the Supreme Court was stated long ago by Mr. Justice Holmes when he said, and I quote, "The theory of our system is that the conclusions to be reached in a case will be induced only by evidence and argument in open court, and not by any outside influence, whether of private talk or public print." Now, this was said in 1907, before the great media of radio and television existed. I'm sure that if he were speaking today, he would include those great media within the scope of public print. Now, as I have said, the Supreme Court has indicated that a defendant is entitled, as part of due process of law, to a fair and impartial jury trial free from outside influence. I pose this question. After all the publicity given these hearings and the Watergate situation in general, where in the United States can an impartial jury, uninfluenced by publicity, be found? Moreover, under our settled system of due process of law and justice, guaranteed by the Fifth Amendment, an accused has a right to remain silent, completely silent, and require the government to go forward with the presentation of its evidence before the defendant need present his case or put on any evidence. By requiring Mr. Stans to appear here before one of the coordinate arms of the government which has placed these charges would require Mr. Stans to present his case in advance of hearing the government's case in New York. This clearly would deprive him of due process of law. If Mr. Stans refuses to testify, as we understand it, he would be under a severe threat of citation for contempt of Congress and would face imprisonment. This places him under compulsion of either interfering with his own fair trial or going to jail. I repeat, this is a completely unfair position to put him in. The only other alternative open to Mr. Stans, Mr. Chairman, is for him to refuse to testify on the grounds of the Fifth Amendment. This would tend to degrade and embarrass him and would severely interfere with fair trial, because he would be branded throughout the United States as a former cabinet officer who had taken refuge behind the Fifth Amendment. What would a prospective juror say about that? The courts have recognized, and the facts in many cases show, that the taking of the Fifth Amendment, even though it's a constitutional right, is likely to severely prejudice a person in the mind of the public, including prospective jurors. Mr. Chairman and members of the committee, Mr. Stans has left no reasonable choice or fair opportunity. As lawyers of broad experience, each of you must recognize that fact. Therefore, under the prevailing circumstances, on behalf of Mr. Stans, I respectfully request that the committee, and I strongly urge the committee in the interest of fairness and fair trial, defer Mr. Stans' appearance and testimony until the indictment in the Vesco case in New York has been disposed of. It is probably already too late to preclude the publicity which will make a fair trial in that case impossible. However, I sincerely pray that the committee will at least not make the situation worse by proceeding at this time with Mr. Stans' testimony. Thank you, Mr. Chairman and members of the committee.
Well, Mr. Barker, you've made a very appealing statement to the committee. In view of the fact that the committee was apprised in advance of the nature of the position which would be taken in behalf of the witness, the committee considered this matter at great length this morning. This committee has been authorized and directed by a unanimous vote of the Senate to investigate the question whether any persons acting individually or in combination with others engaged in illegal or unethical or immoral activities in connection with the presidential election of 1972 or in connection with any campaigns of any candidates seeking nomination to run in that election, which had the effect of perverting the integrity of the process by which presidents of the United States are nominated and chosen. I noted your statement that the only effect of requiring the witness to testify would be to prejudice his rights. I don't think that's the only effect of taking this testimony, because taking the testimony of this witness and the testimony of other witnesses will enable this committee to determine whether the activities suggested took place, whether those activities imperil the integrity of the process by which the people of the United States select the occupant of the highest office within their gift, that is, the presidency of the United States, and whether any new legislation is necessary or advisable to punish or prevent a recurrence of any activities which the committee may find were illegal or unethical or improper. Now, the people of the United States certainly have a paramount interest in what those who exercise high governmental power are discharging or failing to discharge their duties. They have high interest in learning whether or not electoral processes for the nomination and selection of presidents have been polluted. And I do not think, and I think the committee, that we should put off an investigation of these matters until they can be determined by the court, because the Constitution gives the Senate that not only the power but the duty to make investigations of this character. And the courts have had approximately a year to deal with these matters, and justice has a habit of treading on leaden feet. So I certainly think it would be manifestly unfair, and the committee concedes of this to be true, and the committee has authorized me to state that in the unanimous judgment of the committee that no questions should be directed to the witness in respect to the matters alleged in the indictments in the United States District Court in New York. And I would like to advise you and the witness at this time that if any question should be put to the witness which inferentially would require any testimony about the matters involved in that case, that it be called to our attention so we can be certain that it will not be answered. Of course, the defendant has a constitutional right under the Fifth Amendment to refuse to testify if his testimony would tend to incriminate him. And I can understand the reluctance of the witness to invoke that right. The committee, as I say, fortunately you gave them advance notice to the committee counsel. We've considered this matter fully, and it's the judgment of the committee, first, that the witness will not be asked any question relating to the New York case. Second, that the witness or his counsel will be privileged to call attention to the committee to any question which might invade the field covered by that case. And third, that it's the duty of the committee, in the absence of an invocation of a constitutional right not to testify, to interrogate the witness. And so the committee will require the witness, in the absence of an invocation of a constitutional privilege, to testify.
Mr. Chairman, just for the purpose of the record, I'd like to clarify the ruling of the committee then. Mr. Stans is appearing here today under subpoena. He, in order to protect his right of fair trial, has not volunteered to be here today. And now the committee is directing him, under the penalty of citation of contempt of Congress, to proceed to testify. Is that correct, Mr. Chairman?
The committee is directing him to testify, and the committee recognizes, as you as one learned in the law, that a refusal to testify under these circumstances, without an invocation of the constitutional principle set out in the Fifth Amendment, would subject the witness to the possibility that the Senate might order the issuance of a citation for contempt if he refused to, of the Senate, if he refused to testify.
Is it the position of this committee, if Mr. Stans does not proceed to testify, that they would seek a citation for contempt against Mr. Stans?
Well, that would be a matter that the committee would have to consider, and since that condition hasn't arisen, we haven't passed on that. But I would say that it would be certainly within the prerogative of the committee to recommend to the Senate, in the event that the witness refused to testify without invoking the Fifth Amendment, that he be cited by the Senate for contempt of the Senate.
Mr. Chairman, the point I'm trying to make, I'd like at this point, for the record, our letter to you dated June 4, 1973, concerning Mr. Stans' appearance, to be made part of the record at this time.
That will be done.
And, Mr. Chairman, what I'm trying to make is a matter of record, that Mr. Stans is not doing anything voluntarily which would waive his right to contest in the proceeding in New York whether he can get a fair trial and whether the indictment should be dismissed on the grounds it's impossible for him to get a fair trial. And I want to make clear that you're ordering him to testify and that he is not proceeding under circumstances which would waive that right.
Well, in the absence of any objection to the contrary from any member of the committee, I would state as chairman of the committee that you have made it perfectly clear. Please refrain from laughter. You've made it perfectly clear, and Mr. Stans has made it perfectly clear to the committee that he is not voluntarily appearing to testify, and that any testimony he may give to the committee is given to the committee merely because the committee orders him to give such testimony.
Thank you, Mr. Chairman. I'd like to take just a moment to check Mr. Stans. I don't need any resources.
I want to say something before you start.
Mr. Chairman, Mr. Stans will proceed under those circumstances.
I think there may be some other member of the committee that may want to make some remarks at this time before we proceed further.
Mr. Chairman, Mr. Chairman, I thank you for the opportunity to make one brief remark, which has nothing to do really with the legal maneuvering that has gone on here. I fully understand the importance of these exchanges. I simply wanted to say on, I believe, behalf of the committee, certainly on behalf of this senator, that the committee is not insensitive to the rather delicate position that Mr. Stans finds himself in. We are not insensitive to the whipsaw between the judicial system and the legislative system, which would appear on the surface. But I think 2 or 3 observations might be appropriate to set the stage and to create the right atmosphere for us going forward at this time. We are not ordering Mr. Stans to testify simply to serve the purposes of this committee's desire to proceed. We are, as a coordinate branch of the government, proceeding with the mandate given us by the Senate. The case, the Delaney case, to which counsel referred, if my memory serves me, was a case that tested this theorem and went out on the question of whether or not the court, under these circumstances, should delay and continue criminal prosecutions until after the legislative proceedings had been concluded. I do not suggest to the United States District Court for any district of the state of New York, or that in which this case is pending, that they should grant a continuance. I rather say, nor do I suggest that you should ask for a continuance. I rather say that there are remedies other than disposing of this witness without his testimony and without suspending the proceedings of this committee in view of the coordinate branch conflict which is presented. On the question of fair trial, if for no other reason than human sensibilities, I'm concerned for a fair trial for any defendant, especially any defendant charged with any violation of the law in conjunction with the so-called Watergate situation or presidential campaign activities of 1972. I'm very concerned for a fair trial for the government and for the defendant. But I suggest, for whatever it's worth, that this committee is in a position to develop the circumstances and the involvements, to do it fairly and openly, to do it publicly, to do it as a forum creating an opportunity for the witness to state his side of the case so that potential jurors do not have just rumor, innuendo, inferences, and conclusions on which to base judgment. And to suggest there's a far greater likelihood, in my view, that a fair jury, an impartial jury, and a fair trial might be obtained after these hearings and after everyone has had his opportunity to testify than would have been the case only a few months ago before a public exposition of all the facts and circumstances attendant on Watergate and the involvements described had been undertaken by this committee. No one can be certain of that result, but I am certain, I hope, for that result, because I hope that these committee hearings do not prejudice the right to a fair trial, but in fact enhance the right to a fair trial. I pledge before you begin that I will not inquire into any matter that I or you suggest in good faith might be involved in the trial of the Vesco case. I urge you to caution your client in that respect and pledge on my part that no refusal to answer on that legitimate basis will be viewed by the committee or this member of the committee as a failure of cooperation. I believe, in conclusion, that this legislative committee, this committee of the Senate, a coordinate branch of the government, can proceed with its mandate as required by the resolution which created it without jeopardizing fairness of trial for either the government or the defendant. It's my fervent hope that we conduct ourselves in that way. Thank you.
In a further statement, I would just like to add that I agree with Senator Baker's observation that the chances, since there's been so much publicity in the press, that the chances of getting a fair trial for anybody that may be involved would rise with the completion of this hearing rather than postponement of this hearing. And as I construe the United States Supreme Court decision in the Hutchison case, the committee is acting within the constitutional limits. And I'd also like to say this, Mr. Barker, as one who admires legal craftsmanship, I want to commend the excellence and the eloquent manner in which you have undertaken to protect what you conceive to be the rights of the witness.
Thank you, Mr. Chairman.
We might let the other attorneys, if there are, that identify themselves for the record, and you might do the same, Mr. Barker.
Mr. Chairman, I'm Robert W. Barker. I'm accompanied by Walter J. Bonner and Leon T. Nauer.
Mr.
K-N-A-U-E-R.
Mr. Stans, will you stand up?
Mr. Chairman, I would like to proceed with an opening statement which will take me approximately 20 minutes, perhaps a minute or two over. And
Yes. I was thinking maybe to administer the oath and then recess, and we'll certainly let you take perhaps it'd be better to make your opening statement after the recess.
It's quite agreeable either way, Mr.
Yes.
Chairman.
Will you stand and raise your right hand? You swear that the evidence that you shall give to the Senate Select Committee on presidential campaign activities shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
We normally recess at noon till 2 o'clock. At that time, we will give you an opportunity to read your entire statement, and I would suggest that you be allowed to read your entire statement without interruption by questions.
Thank you.
The committee will stand in recess till 2 o'clock.
So having spent all that time deciding whether Mr. Stans was going to testify and under what terms, they got him up to the point of holding his hand up in the air to be sworn in and then broke for lunch. Well, we'll take a little break now, and we'll be back with Mr. Stans' statement to the committee in a moment. We'd just like once again to express our gratitude for the response that public television has had to this gavel-to-gavel coverage in prime time. The response in mail has been overwhelming, and so it has in the number of viewers. In at least one city, this gavel-to-gavel coverage in the evenings has attracted as many viewers as the most popular dramatic program public television has shown there. Public television's coverage of the hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service.
I hope that these committee hearings do not prejudice the right to a fair trial, but in fact enhance the right to a fair trial. I pledge before you begin that I will not inquire into any matter that I or you suggest in good faith might be involved in the trial of the Vesco case. I urge you to caution your client in that respect and pledge on my part that no refusal to answer on that legitimate basis will be viewed by the committee or this member of the committee as a failure of cooperation. I believe, in conclusion, that this legislative committee, this committee of the Senate, a coordinate branch of the government, can proceed with its mandate as required by the resolution which created it without jeopardizing fairness of trial for either the government or the defendant. It's my fervent hope that we conduct ourselves in that way. Thank you.
Any further statement? I would just like to add that I agree with Senator Baker's observation that the chances, since there's been so much publicity in the press, that the chances of getting a fair trial for anybody that may be involved would rise with the completion of this hearing rather than postponement of this hearing. And as I construe the United States Supreme Court decision in the Hutchison case, the committee is acting within the constitutional limits. And I'd also like to say this, Mr. Barker, as one who admires legal craftsmanship, I want to commend the excellence and the eloquent manner in which you have undertaken to protect what you conceive to be the rights of the witness.
Thank you, Mr. Chairman.
We might let the other attorneys, if there are, that identify themselves for the record, and you might do the same, Mr. Barker.
Mr. Chairman, I'm Robert W. Barker. I'm accompanied by Walter J. Bonner and Leon T. Nauer.
Mr. Mr. Stans, will you stand up?
Mr. Chairman, I would like to proceed with an opening statement which will take me approximately 20 minutes, perhaps a minute or two over. And
Yes. I was thinking maybe to administer the oath and then recess, and we'll certainly let you take perhaps it'd be better to make your opening statement after the recess.
It's quite agreeable either way, Mr. Chairman.
Will you stand and raise your right hand? Do you swear that the evidence that you shall give to the Senate Select Committee on Presidential Campaign Activities should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
We normally recess at noon till 2 o'clock. At that time, we will give you an opportunity to read your entire statement, and I would suggest that you be allowed to read your entire statement without interruption by questions.
Thank you.
The committee will stand in recess till 2 o'clock.
So having spent all that time deciding whether Mr. Stans was going to testify and under what terms, they got him up to the point of holding his hand up in the air to be sworn in and then broke for lunch. Well, we'll take a little break now, and we'll be back with Mr. Stans' statement to the committee in a moment. We'd just like once again to express our gratitude for the response that public television has had to this gavel-to-gavel coverage in prime time. The response in mail has been overwhelming, and so it has in the number of viewers. In at least one city, this gavel-to-gavel coverage in the evenings has attracted as many viewers as the most popular dramatic program public television has shown there. Public television's coverage of the hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
In this third hour of the hearings, Maurice Stans will explain his role in the Nixon campaign, one that he says was separate from that of the strategy makers. And he'll cover the circumstances leading up to a $25,000 campaign contribution going into the bank account of convicted Watergate burglar Bernard Barker.
Committee will come to order. Since the witness will first read a written statement of which Senator Baker has a copy, while we'll go and proceed. I imagine Senator Baker will be in any minute.
Mr. Chairman and members of the committee, I'm very sorry that the circumstances of my appearance made it necessary for my counsel to raise legal points in order to protect my right of fair trial in New York. I personally would have much preferred to testify without any need to protect myself in that criminal action, in which I feel that in the setting of a fair and impartial trial, I would be exonerated. However, I want to assure you now that I will do my very best to be helpful to the committee in my testimony. Less than 2 years ago, one of the proudest moments of my experience occurred on the Senate side of the Capitol as I approached the end of my service as Secretary of Commerce. Some of you and many of your colleagues on the Senate Commerce Committee were extremely generous in a public hearing in praise of my efforts over a 3-year period as head of the Department of Commerce. And some of the Democratic senators even wished me success in my new undertaking as a fundraiser, but not too much success, they said. All of those comments remain highly valued to me now, as much as any reward for the many years I spent in public service in 2 administrations. I would like my appearance here today to be another service in the public interest. The circumstances that bring us together are extremely regrettable, but I still share a strong mutual concern with you, in this case, in establishing the facts and the truth of these matters of national interest. For that reason, as you know, I have cooperated with your staff prior to my appearance here today, just as I intend to do fully with the committee here now. My sense of integrity compels me to do so. In the past, I have refrained from answering in a piecemeal fashion the various questions that have been raised by the media concerning the presidential campaign and other related matters. For that, I have been highly criticized. But I felt that it was better if I could answer these questions before an appropriate forum in the setting and perspective of the overall situation. This would enable me to give a complete picture rather than a piecemeal response. And this is what I hope to do today to the extent I am able. This may help resolve some questions as to which there has been a minimum of understanding and much erroneous public information. Next, let me say that I have cooperated fully with every official agency that has sought information from me. I have met twice with the staff of this committee, once with the staff of the House Banking and Currency Committee. I've had 3 meetings with the FBI and 6 meetings with the General Accounting Office. I've given a deposition to the Assistant United States Attorney in Washington. I've met with the Assistant United States Attorney in New York and twice testified before a New York grand jury. All of this has been voluntary. I've also testified several times by deposition in civil suits and once in a Florida criminal case. Also, during all the investigations which have commenced since June 17, 1972, I have instructed all Finance Committee personnel to cooperate fully and candidly. The reported testimony of Hugh Sloan Jr., Paul Barrick, Judy Hoback, Evelyn Hyde, and Arden Chambers is evidence that this is being done. I am convinced that none of these persons had a part in Watergate or the subsequent events. However, as will come out, Mr. Sloan's recollection and mine may differ in a few respects. This is obviously attributable to the passage of time or the pressures of events at the time or subjective recall. Just as he has given you his best recollection, I will give you mine on the various financial matters. On the major issue, that of involvement in the Watergate matter, I'm satisfied that he is completely innocent. Now, it's my understanding that the committee is probing three matters in which it might assume that I have some knowledge. The espionage charges, including the Watergate bugging and the cover-up that allegedly followed. The sabotage charges, including the Segretti operation. And the handling of campaign finances. On these three matters, I would like to state this. First, I had no knowledge of the Watergate break-in or any other espionage efforts before I read about them in the press, or of the efforts to cover up after the event. Second, I had no knowledge of any sabotage program to disrupt the campaign by Segretti or anyone else. Thirdly, to the best of my knowledge, there were no intentional violations of the laws relating to campaign financing by the finance committees for which I had responsibility. Because of the complexity of the new law that became effective in the course of the campaign and the vast amount of work that had to be done under the new law, there may have been some unintended technical violations by the committee. Now, what I want particularly to stress in this opening statement is the fact that this committee cannot effectively evaluate the work of the Finance Committee or my own activities without having four fundamental distinctions in mind. First, the distinction between the functions and activities of the Campaign Committee and the functions and activities of the Finance Committee. Second, the distinction between the election financing law, which expired on April 6, 1972, and the new election financing law, which was effective on April 7, 1972. And next, within the Finance Committee, the distinction between the functions and the activities of the chairman and the functions and the activities of the treasurer. And fourth, the activities of the Finance Committee before I joined it on February 15, 1972, and the activities of that committee after February 15, 1972. By the Campaign Committee, I mean, of course, the Committee for the Re-election of the President. By the Finance Committee, I mean the Finance Committee for the Re-election of the President and its several predecessors up to April 6, 1972, and the Finance Committee to re-elect the President beginning April 7, 1972, together with their associated committees in each time frame. During the period of my affiliation with the Finance Committee as its chairman, the treasurer was Hugh Sloan, Jr. until July 15, 1972, and thereafter the treasurer was Paul E. Barrick. I shall refer to the treasurer as though it were the same individual, letting the time period identify which of these persons it relates to. Now, as between the Campaign Committee and the Finance Committee, the Campaign Committee had all of the responsibility for the planning of the campaign, the development of its strategy, the execution of its tactics. The questions of how many people to employ, the efforts to be expended in each state, the determination of the relative use of direct mail and personal solicitation and media advertising, the kinds of appeals to voters, and the entire gamut of the political effort was developed and organized and managed and conducted by the Campaign Committee. In effect, their decisions fixed the amount the campaign would cost. The Finance Committee had no part in any of these basic decisions. The role of the Finance Committee was directed toward a single objective: to raise enough money to pay the bills. The Finance Committee had nothing to say about which bills to incur. Under the arrangements in effect, the Finance Committee paid any bill or made any payment which bore the approval of an appropriate official of the Campaign Committee. The Campaign Committee was supposed to see that the amounts it okayed were within the limits of an approved budget. It turned out that the controls did not work as they were intended, and spending overran the budget by more than $8 million, perhaps more likely $10 million. So in practical terms, the point I'm trying to make is that the two committees operated in watertight compartments. They were physically separated on different floors. The campaign committee ran the campaign and created the debts. The finance committee raised the money and paid the bills. There was only one forum for the exchange of opinions with respect to campaign spending, and that was the Budget Committee. The Budget Committee consisted of 3 officials of the Campaign Committee and 3 officials of the Finance Committee. Formal meetings of the Budget Committee with recorded minutes did not take place until after Labor Day in 1972. A number of informal meetings on budget matters were held before that, but most of those centered on the overall amount of funding at the national and state levels. The meetings of the Budget Committee were not, in my opinion, very effective. Each one was opened by me with a general statement of the current cash position and the expectations of future contributions, which until the last few days of the campaign never equaled the expected spending. I pressed in these meetings continuously for reductions in the level of spending, but the actual trend was constantly upward. At times, the meetings between the two groups became bitter, and I walked out of one meeting at which I thought there was absolutely no understanding of the difficulties of fundraising on the part of those who were doing the spending. The budget grew to $40 million, then $43 million, ended up in excess of $48 million, and our latest accounting, which is not yet completed, shows it to be in excess of $50 million. Only a late surge of contributions, as a result of the effective organization we had built across the country, made it possible for us to end up with a surplus above that. Now, as between the old law and the new law, prior to April 7, 1972, the controlling law on candidates for federal offices was the Corrupt Practices Act enacted in 1925. This act made a major distinction between fundraising for a candidate to secure a nomination through primaries or conventions and fundraising in a general election. There was no reporting required of any kind on contributions and expenditures to secure a nomination. There was a requirement that contributions and expenditures in a general election be reported to the Clerk of the House. The Federal Election Campaign Act of 1971, which became effective on April 7th of 1972, changed that by eliminating entirely the distinction between a campaign for nomination and a campaign for election. It required that all contributions and all expenditures in a political campaign be reported. Although the bill was signed by the President on February 7th, it did not become effective until April 7th, because the Congress specifically allowed 60 extra days for operation under the old law. The distinction between election financing and nomination financing had existed for almost 50 years, and countless candidates for the presidency, the Senate, and the House of Representatives had observed the requirements of the one and the exemption of the other. In 1972, candidates for such offices in both political parties formed finance committees that did not have to publish or file their transactions prior to April 7th, and organized new reporting committees after that date. In the President's campaign, a finance committee for the re-election of the President had been created solely to raise funds for the renomination, and this committee terminated its activities on April 6th. It was not under the law required to file reports. A new finance committee to re-elect the President was created to operate beginning April 7th, and it has filed all public reports required by the new law. Now, we readily acknowledge that our fundraising operated under the old law until April 7th, 1972. We used the 60-day period allowed by the Congress. Under this law, the fact that contributions need not be reported gave the committee and its contributors a right of confidentiality. The issue of confidentiality versus disclosure of such information has never been fairly presented to the public. It has been made to appear that the committee engaged in secret and thereby concealed and suspect transactions which would not have occurred had they been required to be disclosed. That is not true. The transactions were valid and proper, and the question of whether they were to be reported was a question of law that involved important rights of individuals. The committee's position all along has been that non-disclosure created no advantage to it, but that privacy was a right of the contributor which the committee could not properly waive. The right to live without undue intrusion is a long-respected benefit of the American system. Therefore, the committee did not release the names of its contributors before April 7th. It has never objected to any contributor disclosing his contribution. And on one occasion, just before the election, the committee released a list of such contributors up to March 9th, 1972, only after consulting with those making the larger gifts. Much has also been made of the fact that a few records of the committee before April 7th were destroyed. The fact is that the very large part of such records have been preserved, and the committee believes that the others can be reconstructed if they are needed. But the important point is that there was no illegal act in throwing away any of these records, and even those that were retained could have been disposed of. Not only was there no statutory requirement that records of transactions before April 7th be preserved, it was not even necessary that any books, that any recordings be kept at all. At least that's what our lawyers told us at the time, and that corresponded with what we'd been told in the 1968 campaign. The Finance Committee to re-elect the President undertook to observe strictly all the provisions of the new law beginning April 7th and urged its affiliated state committees to do likewise. Systems and controls were developed to ensure that would be the case. Notwithstanding this, there have been a few instances in which the committee has been cited by the General Accounting Office and the Department of Justice for failure to report transactions which occurred after April 7th. The committee believes that it has valid explanations for this small number of technical violations, and in at least one case, the Department of Justice has ruled in favor of the committee on a citation. And the committee believes that considering the hundreds of thousands of contributions received and bills paid, its record of operation under a new and highly complex law that came into being during the middle of the campaign should be commended rather than criticized. Now, as to the chairman and the treasurer, these are the only two statutory offices required in a political committee. As chairman of the committee, I had a personal responsibility for overall coordination of its activities. The principal vehicle in that respect was a daily staff meeting attended by the treasurer, the controller, the general counsel, and several of the vice chairmen working in Washington. But without doubt, my prime personal responsibility was to raise the money required to finance the campaign. And that occupied almost all of my time and attention. Between February 15th and November 7th, 1972, I visited approximately 45 cities in 32 states to meet with fundraising committees, groups of potential contributors, and individual potential contributors. I also met with individuals and groups in Washington and made hundreds, many hundreds, of phone calls to fundraisers and contributors. And this was not a campaign financed by a few large contributors. To ensure participation by hundreds of thousands of individuals, I directed a direct mail program that reached 30 million homes and a group fundraising program to reach people at their places of employment. Now, these took a great deal of time. As chairman of the committee, I had no responsibility in connection with the internal handling of funds, banking, recording, accounting, and reporting. I did not sign checks. I did not expend cash from the treasurer's cash fund. I did not have a cash fund. It was my regular practice when I accepted contributions for the committee to turn them over to the treasurer promptly. I did not have relationships with the banks. I did not make entries in the books or even see the books. And I did not prepare the public reports and did not review them, except to scan their summary pages. These were all the responsibility of the treasurer. That was not only within the working format of our committee, but it was what was provided under the Federal Election Campaign Act. His was the responsibility for all day-to-day internal operations, and generally I consulted with him only when he came to me for guidance on a specific problem, which was on a limited number of occasions. Now, as to before February 15th and after February 15th, when I joined the committee. When I joined the committee on February 15th of last year, a considerable number of activities were underway and a number of people were in place. Fundraising and campaign activities had been engaged in almost a year. Programs had been planned or committed by the campaign people. Funds had been collected and dispersed. Committees had been formed and terminated. And some well-publicized transactions had already occurred. Patterns of payment to Herbert Porter and Gordon Liddy were a practice. Magruder had blanket authority to direct payments. Kalmbach had turned over to the committee the funds in his possession. But no steps had been taken to comply with the new law, and the procedures generally were inadequate to cope with the volume of work sure to come. When I joined the committee, the bank balance was about $3 million, and there was still $30 million or $40 million or more to be raised. I did not review what had happened before, but began to work with the problem at hand. I did not learn about many of the earlier transactions until a much later time. For example, from February 15th to April 7th, I had 45 working days, counting Saturdays, and 13 of these were spent outside Washington. It was not a period of time in which I could spend hours on detail. I trusted the people already in the committee organization. I relied heavily on the treasurer because of his previous experience in 1968, in 1971, and even before 1968. I was after contributions. What I would like to emerge from all of this information are a few simple conclusions. First, the Finance Committee played no part in the strategy or the tactics of the campaign. If they went wrong, it was the fault of the campaign committee. The Finance Committee's only responsibility was to raise enough money to pay the costs that were incurred by the campaign committee. Second, the Finance Committees in existence prior to April 7, 1972, operated under legal advice that their transactions need not be recorded or reported as a matter of law. Third, within the Finance Committee, the chairman's basic job was to raise the money, and the treasurer's basic job was to account for it and disperse it. And fourth, the responsibility of raising the largest amount of money ever spent in a political campaign obviously put massive pressures on the Finance Committee, especially those engaged in fundraising. In my own case, the stress was multiplied manyfold by the serious illness of my wife, which began August 9th and continued into early 1973. Gentlemen, I repeat to you that I had no advanced knowledge of the Watergate affair and no knowledge of any efforts that may have been made to cover it up, nor do I know about any other espionage or sabotage activities on the part of the campaign committee. I can also assure the committee that I have made an honest and careful effort to abide by the spirit and intent of the election laws. Thank you.
Thank you, Mr. Stans. In the chairman's absence and pursuant to a request by Senator Weicker, if there's no objection, Senator Weicker has a brief statement he'd like to make to follow directly after the statement of the witness. Is there any objection to that? Senator Weicker.
Thank you, Mr. Chairman. Chairman and fellow members of my committee, in 1970, I gained the Republican Party's nomination for the United States Senate from Connecticut by way of primary. During the course of that primary campaign, Republicans both within and without Connecticut properly chose sides as between myself and my opponent. It came to my attention that Mr. Maurice Stans, then Secretary of Commerce, spoke in Connecticut against my nomination on behalf of my Republican opponent, John Lupton. His action, I know, was not an indication of any official position taken by the White House. But needless to say, it did not endear me to Mr. Stans. Though I've had no contact with Mr. Stans, and though actually I feel a great compassion for him and his family, I do not want it said by any person or wondered about by Mr. Stans as to whether my questioning of him would be an act of getting even. Therefore, Mr. Chairman, I will refrain from questioning Mr. Stans now or at any time in the future.
Thank you, Senator Weicker. Mr. Edmondson.
Mr. Stans, is it not true that most of your adult life that you've been in the accounting business one way or another?
Yes, that's true of all of my adult life except for 8 or 9 years in government and 8 in banking of one type or another.
And in 1957, you were head of the Bureau of the Budget.
That is correct.
And in 1952, you were the recipient of the American Accounting Association's annual award and the Institute of Certified Public Accountants annual award in 1954, and you were elected to the Accounting Hall of Fame in 1960.
That is correct.
So you would consider yourself a pretty good accountant.
I would hope that others consider me a pretty good accountant.
What is your occupation now, Mr. Stans?
I am in the final phases of winding up the Finance Committee to re-elect the President.
In regard to my previous question, I noted that in looking over some press clippings over the years regarding you that it's been suggested that you are a stickler for details. And as one newspaper man said, a model of fiscal conservatism. Would it be fair to characterize you as that? Would you agree to that?
Well, I would say they're correct on both points. I am a stickler for detail within my area of responsibility. And I am essentially conservative in that I don't believe in spending more money than is necessary for any purpose. That was one of the reasons why I found myself in conflict frequently with the campaign people last year.
Now, prior to February 15, 1972, you were Secretary of Commerce.
That is correct.
Tell the committee, please, prior to your coming to the Finance Committee, what political activities were you engaged in while as Secretary of Commerce?
You mean with relationship to the
upcoming campaign?
Upcoming campaign. In 1971, on a few occasions, I met with Mr. Sloan, Mr. Nunn, and their accountant for the committee after hours, as I recall it, to discuss the accounting procedures that they were going to use in the 1972 campaign. I had no part in the campaign. I had not committed myself to be in the campaign, and I was very strongly of the conviction that I did not want to take on the finance job in 1972, but I did at their request. I sit down with them and discuss some of the accounting procedures that would be helpful to them.
Now, Mr. Stans, I want to ask you if you can identify or know anything about the document I have here. This is purportedly written by Mr. Jeb Magruder, a confidential memoranda for the Attorney General dated July 28, 1971.
I have never seen this memorandum before, to the best of my knowledge.
Would you bring it back? With the indulgence of the committee, I'll read it. This is a confidential memorandum for the Attorney General. Dick Whitney, who is Secretary Stans' political special assistant, spent some time with me discussing 1972. One idea which he brought up might be useful in other departments. The Secretary has built up a discretionary fund at Commerce that will total approximately $1 million. He is using this fund for conferences, hiring, and other activities that will be beneficial to the President's reelection. If you feel it is appropriate, Secretary Stans might discuss this concept with other Cabinet officers to see if they can develop the same kind of fund within their own departments. Now, down below there is a line for approve, disapprove, comment, and this, as I said, was signed by Mr. Jed Magruder to the Attorney General, dated July 28, 1971. What can you tell us about that?
I can't tell you very much about it. I have no idea what the concept was. I think it must have been based on some misunderstanding or other. I had no funds in the Department of Commerce apart from the authorized budgeted funds of the department. And I think either Mr. Magruder or Mr. Whitney would be the ones to have to explain that memorandum.
Well, somebody is $1 million off then. In some way, I would take it.
Well, if somebody is implying that we had $1 million set aside in the Department of Commerce to help in the election campaign, I would say they are off. I don't know what it means.
Mr. Chairman, could we mark this for exhibit?
Identification would not be, this market identification. He says he knows nothing about it, so I think it wouldn't be competent until you get somebody that does know something about it, so just hold it.
Now, Mr. Stans, how did you become chairman of the Finance Committee? Who encouraged you to take that responsibility?
Oh, a number of people encouraged me to do it. I guess I became chairman by default, and in the absence of another candidate for the job, I eventually ended up volunteering to the President early in January 1972.
Now, in your statement, you mentioned that there's a good deal of difference between the Finance Committee and the actual campaign committee. Did you not have anything to do at any time with the campaign committee?
I had nothing of any significance to do with the campaign committee at any time, except insofar as I sat as a member of the Budget Committee.
Did you, on May 10, 1972, write a memo to the Honorable John M. Mitchell in which you discussed a number of issues regarding the various open budget matters? And may I show this memorandum to you?
You don't need to. I'm very familiar with that memorandum.
Yes.
And I certainly did write it. I wrote it under the circumstance I described in my opening statement. I was frustrated, upset at the level of spending that was projected by the campaign people, and I proposed a number of reductions in the budget.
Yes. Now, you pretty well, though, covered the whole area of the campaign in this memo, didn't you? For instance, number 1 was November Group, number 2, Convention, 3, Republican National Committee, 4, National Campaign Budget. You were rather familiar with the operation of the campaign committee. If you were able to write this extensive a memo, I would take it.
Well, I don't think that's quite the right way to say it. I was not very familiar at all with the operation of the campaign committee. I was only familiar with their objectives as to how much they were going to spend and approximately a dozen categories in which they were going to spend it. And I was objecting to the total amount that they were going to spend.
Mr. Chairman, could we have this one marked? It is a memo from Mr.
Yes,
Stans.
I understand he identified it, said he wrote it, marked it appropriately, and numbered it appropriately as exhibit and receive it as such.
Now, Mr. Stans, what was Gordon Liddy's position in the campaign?
Gordon Liddy was general counsel to the campaign committee until around the end of March. And then he became general counsel to the finance committee.
And then, during his tenure in the finance committee, you relied upon his advice a good deal.
I relied upon his legal advice a great deal.
Right. Now, did he give you the advice regarding the pre-April 7 contributions and those after? Did you rely upon his legal advice?
Yes, as one of the sources of legal advice, I did rely on his.
Were you aware that he was receiving cash from Mr. Bart Porter and Mr. Hugh Sloan?
Prior to April 7th, I was aware that he had received cash on some occasions. I was not aware of the amounts in total or on any one occasion, and I was not aware that the total was anywhere as large as it was. I thought it consisted of relatively small amounts of money.
What?
I had heard at one point or another that Mr. Liddy was receiving money to use in the primaries.
And that is the only reason that you had knowledge of, or that was brought to your attention?
It was one of the things that was mentioned at one time or another.
Now, I'm sure, Mr. Stans, that you're familiar with Mr. Sloan's testimony before this committee, that he discussed with you a payment of $83,000 to Mr. Liddy. Now, what's your testimony to that transaction?
Somewhere around the 6th of April, Mr. Sloan came to me and said that Gordon Liddy wanted a very substantial amount of money. I don't recall the amount he named, and last August, which was much closer to the time, I recalled in testifying in a deposition to the Federal District Attorney's Office that I thought the amount was $30,000. But I recall that only vaguely. In any event, I don't think the amount is very important. Mr. Sloan said, Liddy wants a substantial amount of money. Should I give it to him? And I said, I don't know. I'll find out from John Mitchell. I'll quote my conversation with John Mitchell as best I can paraphrase it. It isn't precise. But I saw John Mitchell a relatively short time after and said, Sloan tells me that Gordon Liddy wants a substantial amount of money. What's it all about? And John Mitchell's reply was, I don't know. He'll have to ask Magruder, because Magruder's in charge of the campaign and he directs the spending. I said, do you mean, John, that if Magruder tells Sloan to pay these amounts or any amounts to Gordon Liddy, that he should do so? And he said, that's right. Now, that's my recollection in a paraphrase of the discussion that took place. I went back to Sloan and reported it to him and found out that he had already talked to Magruder and had the same information.
Now let's go through the transaction that Mr. Sloan testified to here with payment of cash to Mr. Herbert Porter after April 7th. Did he have a conversation with you?
I'd like to go back to the previous answer and add one more point. Apparently, from the testimony, Mr. Liddy showed Mr. Sloan a budget of $250,000 against which he intended to draw. To the best of my knowledge, Mr. Sloan didn't tell me about that budget, and I didn't know that Mr. Liddy had authority to draw an amount of money of that size. Now, with respect to Bart Porter, I think that Mr. Sloan's recollection is somewhat confused because my understanding of it is somewhat different. I had learned prior to April 7th that Mr. Porter had a cash fund in his safe, that he sometimes received money from one or more sources and used it to pay for certain campaign purposes. I objected to that because I wanted there to be only one treasurer in the campaign. And there was an understanding, which Mr. Sloan has confirmed in his testimony, that Mr. Porter would not receive any more money from him. And to the best of my knowledge, he did not receive any money from Mr. Sloan after April 7th. Now, subsequently, some date in August, I asked Mr. Sloan how much money he had given Porter after April 7th, and he said none. More importantly, on September 6th, I met with Mr. Sloan's attorney and my attorney, the attorney also for the committee, to learn some more information about Mr. Sloan's activities after April 7th. And Mr. Sloan's attorney told me that after April 7th, Sloan had given Porter only $500. And both the committee's attorney, Mr. Parkinson, and I have our notations of that conference. And subsequently, as you know, it was developed that Mr. Porter had received $5,300 from Mr. Sloan, and that was cited by the General Accounting Office. Later it evolved that the amount was $11,000, and I understand Mr. Porter testified last Thursday, that he received $17,000 from Mr. Sloan. So I have no knowledge of those transactions or the use to which they were put, except as I have learned subsequently in testimony.
So we have some conflicting testimony again regarding transaction, I would say.
I don't want to be critical, but I believe that Mr. Sloan's memory in that respect is faulty and perhaps confused. He may have discussed with someone else the question of authority to give money to Bart Porter.
Now, Mr. Stans, did you learn of a payment of cash in the sum of $350,000 from the Finance Committee to Gordon Strawn, and when that payment was made?
Yes, I learned a little bit more about it, I think, than Mr. Sloan did, because back in February of last year, I heard from someone, I think it was Mr. Kalmbach, but I'm not sure, that the White House would like to have some of the 1968 money that he had turned over to our committee to use for special polling purposes. No amount was mentioned at that time. And I have no recollection of any other discussion about the subject until after the $350,000 was given by Mr. Sloan and Mr. Kalmbach to Gordon Strawn. I believe that Mr. Kalmbach takes full responsibility for that transaction. At a later date, I asked Mr. Sloan if the White House had ever gotten the money it wanted, and he said yes, they got $350,000. I don't think that's material. The difference in our recollections is material on this point, because I certainly would not have objected to the item in any event had I been asked about it beforehand. I did not object to it when I heard about it in February. I think it was a perfectly proper transaction.
Now, Mr. Stans, I don't want to drag this out, but I think the committee does want to know something about all of the allegations that have been made regarding 4 so-called Mexican checks, $89,000 drawn on a Mexican bank account. I think it's time for you, in your own words, to describe what you know about that and what you did about it and who you discussed the matters about it with.
I'll be very happy to tell you, because I don't think the full story has ever been told in one place before. And this is my recollection of the sequence of events. On April 3rd of last year, I received a telephone call from Bill Lidke, who was then our finance chairman in the state of Texas. He said, I have a United States citizen residing in Texas as a prospective contributor for $100,000 but he wants to give it in United States funds that are now in Mexico. Is this legal? I said, I'm quite sure it is, but let me check again and I'll call you back. I checked with our counsel, found out that it was perfectly legal for a United States citizen to give any foreign funds he wanted. I called back to Liddy and told him so, to Lidke and told him so. Now, the next thing that I knew about the transaction was after April 22nd, when I came back from a vacation. And at a meeting, I learned from Mr. Sloan that on April 5th, Mr. Lidke's representative, Roy Winchester, had brought to Washington to the committee $100,000 in the form of a contribution from an unnamed person. That it was in the form of checks drawn on American banks by a Mexican bank. That he was not sure how to handle checks of that nature. And that he set them aside. They had clearly arrived before they changed in the law on April 7th. That he set them aside to talk to counsel for the committee and did so the following week. The committee counsel suggested that they be reconverted into cash, into dollars, and took the checks from Sloan for that purpose. When I got back from my vacation, as I said, I found out about the checks. I found out he had given them to counsel. And I found out that the proceeds of the checks had not yet been returned. At this point, I was under the understanding that the 4 checks totaled $100,000. And I didn't know until I read in Time magazine, somewhere along the line there, that the 4 checks totaled only $89,000 and that $11,000 of the 100 was in currency. Now, from here on, I have to quote what Mr. Sloan said, because I had not seen the checks, nor did I see the proceeds of the checks come back to him. But according to him, the proceeds of the checks came back to him less a collection fee of $2,500 that was imposed on it, and he held the money and included it in a bank deposit that was made on May 25th. Now, that's my recollection of the transaction. You may have other questions about it.
No, I will leave those for the senators.
I'd like to point out, though, that the General Accounting Office has concluded that the funds were properly received before April 7th and that there was no requirement to report them.
Now, what did you have to do with the so-called Dahlberg check? You received a cashier's check, did you not, from a Mr. Dahlberg?
Yes, may I recite the complete sequence of that transaction as I understand it? Kenneth Dahlberg was a member of the early finance committee working in the state of Minnesota, and Dwayne Andreas was a Minnesota resident who also had a place of living in Florida in a hotel that he owned. As I understand it from Dahlberg, somewhere around as early as January, Andrea said, I want to help the president's campaign, I'll give you $25,000 when you get around to it. He confirmed that to Dahlberg in February. In March, on the 12th, and this I get from Andreas, he decided to get the money in hand. And he decided to make the contribution in cash because he was a close friend of Hubert Humphrey and a contributor to Humphrey's campaign, as well as a friend of the president. And he wanted to achieve all the anonymity he could achieve. On the 12th of March, he instructed his secretary to get together $25,000 of money which he did from a tax-paid account, and put it in an envelope to be given to Mr. Dahlberg on the 15th of March at a meeting of a board of directors of a bank of which both Dahlberg and Andreas were directors. Unfortunately, on the 14th, Dahlberg found suddenly that he had to go to Europe to deal with the affairs of an affiliated company there, and he couldn't attend the meeting. So Andreas continued to hold the money in an envelope. On the 5th of April, having in mind the change in the law that would take place in the next day or so, Andreas in Florida called Dahlberg in Minnesota and said, "I still have that money. I'd like to give it to you before the change in the law. Can you pick it up?" And Dahlberg said, "I can't get down there before the 7th. I will get down there on the 7th and arrange to pick it up." Andreas said, "Well, I want the contribution to be made now, made effective now. So I will put it in an envelope in your name and put it in the safe deposit box in the hotel in your name. And you can pick it up whenever it's ready, but I want the understanding between you and me the title is passed and that it's your money and you accept it as of today." Dahlberg said, "I do," and called me and relayed the transaction, and I advised him on the basis of legal advice that I had already received that a commitment of that nature was properly a contribution before April 7th, and when received would not have to be reported. On April 7th, Dahlberg went to the hotel in Florida, arrived too late to pick up the money because the safe deposit boxes were closed. He talked to Andreas on the 8th and arranged for the two to get together on the 9th. And at Dahlberg's request, Andreas took the money out of the safe deposit box and delivered it to Dahlberg on the 9th. On the 10th, Dahlberg bought a cashier's check for it because he did not want to carry that amount of money around with him from Florida to Washington, where he was due on the 11th for a meeting of all of our state finance people in our committee. On the 11th, at an intermission in the meeting, Dahlberg endorsed the check and handed it to me with the explanation that this is the money from Andreas. And I had a full accounting of the sequence of the transaction up to that date. I thereupon, the same day, as quickly as possible, gave the check to the treasurer, explained to him the background, that this was money which had been contributed before the 7th, and asked him to determine the accounting handling of the check. The treasurer, not being sure, discussed it with the general counsel for the committee. And the general counsel suggested that he take the check and convert it into cash. The treasurer gave him the check. Now again, I can report what the treasurer has said, that he did not get the proceeds of the check back until sometime in May. He received them in full, and they were deposited in a bank account on May 25th. Now, as to those two transactions and several others in a similar category, we treated that as cash on hand on April 7th and reported it in the report of the Media Committee to re-elect the President in the amount of $350,000. And that exact amount of $350,000 was deposited in that committee's bank account on May 25th. We felt that we had complied with every requirement of the law as to the handling and reporting of that money. We had accounted for it fully. The General Accounting Office subsequently cited our committee for a possible violation of the law in failing to report the $25,000. But the Department of Justice in a letter some months later, concluded that there was no violation of the law in the handling of that transaction.
Now, Mr. Stans, when was the first time you learned that these checks had cleared through a bank account of a Bernard Barker?
It was well after the Watergate event of June 17th.
Now, shortly after that, did you have any discussions with Mr. John Mitchell or anyone at the White House concerning any of these checks during the week immediately following?
I don't recall any specific conversation with John Mitchell, but I do recall a conversation with Fred LaRue and subsequently with Robert Mardian.
What did you talk about?
As I recall it, it was the morning of the 23rd of June, which was 6 days after the Watergate affair. I received a phone call from Fred LaRue saying, "Do you know Kenneth Dahlberg?" And I said, "I certainly do." He said, "Well, his contribution ended up in a bank account of one of the fellows who was arrested." I said, "Dahlberg didn't make a contribution." He said, "Well, it's his check." So he came down and we discussed it and concluded that in some manner or other, Dahlberg's check must have reached the bank account of Bernard Barker. We called Dahlberg and discussed it with him, got him to Washington on that same day, met with him, and he met with LaRue and I think with Mardian, and got all the facts of the transaction in hand. It was clear that neither Dahlberg nor I nor Hugh Sloan had anything to do with the checks, that check or the Mexican checks, entering the Barker bank account. They could only have gotten there through the hands of our general counsel, Gordon Liddy, who had taken them into his custody.
Mr. Stans, I'm going to skip along. I don't want to encroach on eternity. At one time, did you approve or assent to giving Mr. Fred LaRue $80,000?
Yes, I did. Would you like to know the background
Yes,
of that?
when was that?
On the same day of June 23rd, when Mr. Sloan had balanced out his cash account, something which I had asked him to do as early as April 10th, but which he couldn't do because he was waiting for the return of the proceeds of the various checks we've been discussing. He showed a balance of $81,000 of cash on hand and expressed some concern about it because he was going on vacation. And under the tense situation that was building up, and the general counsel suggested that he take the check and convert it into cash. The treasurer gave him the check. Now again, I can report what the treasurer has said, that he did not get the proceeds of the check back until sometime in May. He received them in full and they were deposited in a bank account on May 25th. Now, as to those two transactions and several others in a similar category, We treated that as cash on hand on April 7th and reported it in the report of the Media Committee to re-elect the President in the amount of $350,000. And that exact amount of $350,000 was deposited in that committee's bank account on May 25th. We felt that we had complied with every requirement of the law as to the handling and reporting of that money. We had accounted for it fully. The General Accounting Office subsequently cited our committee for a possible violation of the law in failing to report the $25,000. But the Department of Justice, in a letter some months later, concluded that there was no violation of the law in the handling of that transaction.
Now, Mr. Stans, when was the first time you learned that these checks had cleared through a bank account of a Bernard Barker?
It was well after the Watergate event of June 17th.
Now, shortly after that, did you have any discussions with Mr. John Mitchell or anyone at the White House concerning any of these checks during the week immediately following?
I don't recall any specific conversation with John Mitchell, but I do recall a conversation with Fred LaRue and subsequently with Robert Mardian.
What did you talk about?
As I recall it, it was the morning of the 23rd of June, which was 6 days after the Watergate affair. I received a phone call from Fred LaRue saying, "Do you know Kenneth Dahlberg?" And I said, "I certainly do." He said, "Well, his contribution ended up in a bank account of one of the fellows who was arrested." I said, "Dahlberg didn't make a contribution." He said, "Well, it's his check." So he came down and we discussed it and concluded that in some manner or other, Dahlberg's check must have reached the bank account of Bernard Barker. We called Dahlberg and discussed it with him, got him to Washington on that same day, met with him, and he met with LaRue and I think with Mardian, and got all the facts of the transaction in hand. It was clear that neither Dahlberg nor I nor Hugh Sloan had anything to do with the checks, that check or the Mexican checks, entering the Barker bank account. They could only have gotten there through the hands of our general counsel, Gordon Liddy, who had taken them into his custody.
Mr. Stans, I'm going to skip along. I don't want to encroach on eternity. At one time, did you approve or assent to giving Mr. Fred LaRue $80,000?
Yes, I did. Would you like to know the background of that?
Yes, when was that?
On the same day of June 23rd, when Mr. Sloan had balanced out his cash account, something which I had asked him to do as early as April 10th, but which he couldn't do because he was waiting for the return of the proceeds of the various checks we've been discussing. He showed a balance of $81,000 of cash on hand and expressed some concern about it because he was going on vacation. And under the tense situation that was building up, he didn't want to hold the cash in his custody. We discussed it and concluded that the funds were of a nature which did not classify them as funds of the current committees, that they were more properly funds of earlier committees, that they were not part of what we had to account for in an audit by the General Accounting Office, and that we should get legal advice. At that time, it was understood within the committee that Robert Mardian had been brought to Washington to work on legal matters that were current at the time, and I went to him for advice. His advice, after he found the description of the money, was to get the money out of the office and out of the campaign, and he suggested that I give it to Fred LaRue. Fred LaRue was the right-hand man of John Mitchell, an assistant to Mitchell as campaign director. On that advice, I gave the money, my half of the money, to LaRue, and Sloan later gave his half of the money to LaRue. I neglected to say that when Sloan expressed concern about having that much money in his custody, I agreed to divide it with him so that there would only be about $40,000 in each parcel, and I took one and put it in my desk, and he took one parcel and took it home. I gave mine to LaRue rather promptly at the first opportunity. Sloan went on a vacation to Bermuda for about 10 days and gave his money to LaRue upon his return. Now, there's some uncertainty as to whether that money passed through Mardian's hands in each case. I can't recall whether I gave the $40,000 that I had directly to LaRue or gave it to Mardian to give to LaRue. Sloan did give his $40,000 to Mardian, and Mardian gave it to LaRue.
Do you know what happened to that money in the end?
I do not know specifically what happened to that money. Subsequently, I received some funds for several purposes from Fred LaRue. Whether it was part of the same money or other money, I have no way of knowing. Only he could tell.
Now, Mr. Stans, in late June or early July, did you receive a call from Mr. Herbert Kalmbach requesting money from you?
On the 29th of June, I received an urgent call from Mr. Kalmbach. He said he was in Washington at the Statler Hilton Hotel. It was extremely vital that he see me right away, and he wanted me to come over there, and I did. I dropped everything and went over to see him. He said, I'm here on a special mission on a White House project. I need all the cash I can get. He said, I don't have any cash to give you. Will you take a check? He said, no, I can't take a check. It must be in cash, and this has nothing to do with the campaign. But I'm asking for it on high authority.
What high authority did he say?
He did not say. I'm asking for it on high authority, and you will have to trust me that I have cleared it properly. As I said, I had no cash belonging to the committee at that time because we had closed it all out. But I did have 2 parcels of money that were available, and I gave those to Mr. Kalmbach. They added up to $75,000 as funds outside the committee.
Now, Mr. Stans, did you not ask him why he wanted this money?
Yes, I did.
What did he say?
He said this is for a White House project, and that I have been asked to take care of, and I cannot tell you. You will have to trust me.
Would Mr. Kalmbach have been your superior in this organization, campaign organization?
No, Mr. Kalmbach was a man I knew very well. He had been my principal deputy in the 1968 fundraising campaign for Richard Nixon. He subsequently had close affiliation with a number of people in the White House that I was aware of. He was personal counsel to the President. He was a man that I knew as a man of the highest integrity, trustworthiness, and honesty, and I had no question to doubt, no reason to doubt anything he told me, and I didn't.
Who in this whole organization would you consider your superiors, and would you just go up the line from you?
Well, I don't know that I had any superiors. It was a unique situation. The Finance Committee was separate from the Campaign Committee. The Campaign Committee exercised a dominance over the Finance Committee by their spending policies, forcing us to raise enough money to pay everything they committed. But I had no superior. I would have taken instructions from the President if he gave me any, but he didn't. And I would have been influenced by requests from certain people in the White House from time to time. But I don't believe I had a superior in that sense.
Well, I just have one more question here. Now, I want you to think carefully, Mr. Stans. Did you have a meeting on June the 24th, after the break-in, with Mr. John Mitchell to find out from him what had happened?
I'm not sure of the exact date. I had meetings from time to time with Mr. Mitchell. I probably had one on June 24th.
Did you ask him what happened in that meeting, if you recall it?
I don't recall that I asked him that question. Certainly I was curious about it, and it would not surprise me if I had, but I have no recollection of specifically talking about that subject. That was a week after the break-in.
Yes. Do you recall at any time Mr. Mitchell telling you that there were others involved besides those who were apprehended at a meeting of that nature at about that time?
No, I do not.
When we return, Maurice Stans will still be with us. Public Television's unedited coverage of the Watergate hearings continues after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
All right, now, don't go to bed yet, because in this fourth hour of testimony, Maurice Stans will be questioned about decisions by that famous Budget Committee and the duties of the mystery man to end all mystery men, G. Gordon Liddy.
Yeah, Mr. Sanders.
Mr. Stans, this committee has received testimony from several witnesses and from you today concerning the Budget Committee of the Finance Committee to re-elect the President, That is that it was composed of 3 members from the Finance Committee and 3 members from the Committee to Re-elect the President. And I would like to take just a few minutes to explore some aspects of that committee with you. To begin with, it's been asked of you who your superiors were. No mention in your answer was made of Mr. Mitchell. Did you consider in any way that you had any line or responsibility to him, you being chairman of the Finance Committee and him as chairman of the Committee to Re-elect the President?
No, I didn't really consider that I was subordinate to Mr. Mitchell. We were separate committees, each performing our mission, and we communicated from time to time, and our principal means of discussion about what we had to do to accomplish our mission was in the Budget Committee meetings.
Who designated you to be a member of the Budget Committee?
Mr. Mitchell and I worked that out jointly, that there would be 3 members from each committee.
The Budget Committee then was not in being at the time you became chairman of the Finance Committee.
No, sir, and Mr. Mitchell was not there either at that time.
When did the Budget Committee actually begin to function? Do you recall?
I don't recall precisely, but I think our first meetings were in April. They were irregular. They were not on schedule. There were meetings as material came to hand or questions arose. And in those days, we were trying first to get an overall budget put together on which we could agree. And secondly, we were trying to get budgets from each of the 51 states as to how much would be spent in each state.
Would you please state the membership of the Budget Committee at the time it was constituted?
It was John Mitchell, Jeb Magruder, and I believe Bart Porter on the campaign committee side. It was myself, Hugh Sloan Jr., and Lee Nunn on the finance committee side. But in addition to the 3 from each side, the meetings were attended by 2 or 3 other people from each committee, so that they were a little larger than 6-man meetings.
Did you customarily chair the Budget Committee meetings?
No, we were co-chairmen, but I deferred generally to Mr. Mitchell, and I think he chaired more often than I did.
Who prepared the agenda for the meetings, or were they less formal than that?
Well, for the first number of months, they were very informal. There were no agendas. We began to have agendas after the convention, when we began to deal with the very large amounts of money currently being spent.
To your knowledge, did the Budget Committee ever give consideration to the collection of cash contributions and retention of that in a repository within the premises of the Finance Committee?
The Budget Committee did not deal with contributions. The Budget Committee dealt exclusively with the expenditures of the campaign. Specifically, it did not separately deal with cash transactions.
Realizing that the Budget Committee may not have considered the receipt of cash contributions, nevertheless, did it ever consider the potential use of cash as opposed to the use of funds in bank accounts?
No, there was no distinction between cash and bank accounts in any discussions in the Budget Committee.
Now, there were large sums of money we've been hearing expended for Mr. Liddy, to Mr. Porter, and some still others. To your knowledge, and I presume you either attended all the Budget Committee meetings or were informed what had transpired there if you were not able to attend. To your knowledge, did the Budget Committee ever take under consideration the allocation of any cash funds to Mr. Liddy or to Mr. Porter?
No, the Budget Committee did not specifically deal with any allocation of cash funds to any individual, Porter, Liddy, or anyone else.
To your knowledge, did the Budget Committee ever take under consideration the allocation of funds to be expended for any intelligence gathering operation?
I don't recall ever hearing any discussion of intelligence gathering in the Budget Committee meetings.
Prior to June 17th, Mr. Stans, were you aware that an intelligence gathering operation was underway?
No, I was not. I don't recall hearing any discussion of such an activity.
But, in fairness, Mr. Stans, let me cite to you what I'm getting at here. In the Patrick Gray confirmation hearings, and I have before me the transcript of those hearings, at page 143, it is stated by Mr. Gray that he had checked his records concerning FBI interviews with you. He says that you were interviewed 4 times by the FBI, and that on the last date, which would have been July 28th, you stated to this effect, and I presume he is paraphrasing you here. He says this: Stans became aware from general conversations that Liddy was assigned a, quote, security gathering, close quote, job, and that certain cash disbursements would have to be made available to Liddy.
Well, I think we're talking about semantics here, and I'd like to correct the impression right away. I was told somewhere in May, I believe, by Magruder, that Liddy had a responsibility for security at the San Diego convention. Now, how he was going about on security, I have no way of knowing, and it may well have included intelligence gathering of various types.
Do you have any recollection of making any statement to the FBI that you were aware that Liddy was engaged in intelligence gathering?
I don't recall using that word at all. I do recall testifying before the grand jury, I believe, that sometime before June 17th, that I had learned from Magruder, I believe, that Liddy was working on security for the San Diego convention.
It seems that the line of questioning has developed that one of the problems perhaps with the campaign was too much cash on hand and available for some perhaps questionable purposes. The question naturally arises that as chairman of the Finance Committee, is it reasonable that you did not become aware of the expenditures of such large sums of money, and could these sums have been allocated without the consideration by the Budget Committee? How does this happen? How can this possibly come about?
Well, again, I think you have to break down your consideration of that question to the period before April 7th and beginning April 7th. Now, before April 7th, there were amounts of money received by the committee in cash, going back long before I became finance chairman. After April 7th, there were practically none. There were 1 or 2 transactions which were never completed in the way of contributions in cash, and there were a few contributions in cash which were deposited and fully reported. But most of the cash, very high proportion of it, was received, handled, and dispersed before April 7th, and therefore operated under the old law.
I fully understand that many donors may have wished to make cash contributions for purposes of anonymity. Aside from the cash contributions that have been covered by Mr. Edmiston, that is the Dahlberg and Mexican checks, and we're remaining away from the Vesco matter, did you specifically, in your search for contributions, seek any cash donations?
Let me first put the cash question into perspective. Out of all of the money raised during the campaign, only about 3% was in cash. Out of all the money spent during the campaign, only about 2% was in cash, or less. So that we were not running a bank in which people were running in every day by the hour, handing us cash, and we were dispersing cash. We did have some from people who wanted that extra degree of anonymity. And for those who tendered us cash, we accepted it. And properly so, because the law, as I read it, and as counsel advises me, says we may accept money or anything of value. So we accepted money in the form of checks, we accepted money in the form of cash, and we accepted contributions in other form that we could convert into cash.
To your knowledge, was there any cash goal during the campaign?
A goal to be received in cash?
Yes, sir.
I never heard of one.
At or about the time you became chairman of the Finance Committee, did you have some contact with Mr. Kalmbach, Herbert Kalmbach, concerning the transition, that is the turnover to you of the funds he had on hand and receive an accounting for this?
Yes, that happened before I became chairman of the Finance Committee. But after the time I had agreed to take on the job. Mr. Kalmbach had money in his possession, some of which he had carried over from 1968, and some of which he had accumulated subsequently. It was a substantial amount of money, and I had tried to have the understanding in 1968, and I wanted the understanding in 1972 again, that there would not be separate cash funds in operation outside of the hands of the treasurer. Mr. Kalmbach was totally in agreement with that, and we had an understanding that he would turn in all the funds in his possession, not only before I became chairman, but before the law was signed by the President. And I am told by him and by Mr. Sloan that on February 3rd, Mr. Kalmbach turned over to the Finance Committee all the money that he then had, cash and in bank accounts.
Do you have a recollection of meeting with Mr. Kalmbach prior to that February 3rd date and receiving from him personally some accounting of the funds he had on hand?
Yes, I remember that. Mr. Kalmbach and I met and talked about the very subject we're talking about. Kalmbach gave me a statement showing how much money he still held in bank accounts and in safe deposit boxes.
You recall the date, Mr. Stans?
I think it was January 24th. The date is on the statement, and I believe you have a copy and I have a copy.
Mr. Chairman, I have a document here which I'd like to have marked for identification and shown to Mr. Stans.
The document will be received and marked for identification and shown to the witness. Mr. Stans, before you proceed any further, we've just received a vote signal It's now 3:30, and if you're agreeable to returning, we'll take about a 10-minute break while we go vote and then come back and continue with your question.
I'll stay.
Thank you.
At this point during the testimony of Maurice Stans, the committee took a break for a roll call vote on the Senate floor. And we'll take a little breather now, too. Public television's coverage of the Watergate hearings continues after station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Well, we go back now for the final section of today's hearings, and New Mexico Senator Joseph Montoya is questioning Maurice Stans, the campaign finance director. In this final hour, Stans will explain where he got $75,000 that went to Herbert Kalmbach.
The committee will come to all of them.
Mr. Stans, the exhibit I've just handed you has been marked for identification, and we're going to defer that, and I'd like you to review it again, and we'll take that matter up at such time as you return for further testimony before the committee. I want to ask you a few more questions about Gordon Liddy's assumption of the job as counsel for the Finance Committee. At the time that occurred, were you aware of any conflict that he had been having with Magruder?
No, I wasn't, and I didn't learn about that until quite recently. It's a very interesting development because I'm not quite sure why Mr. Magruder was so generous in giving me Mr. Liddy's services. But on the other hand, I think Mr. Liddy did a good job as counsel. Whatever else he did, may have done for something else. But as counsel, he did an effective job.
Did it ever appear to you that he was perhaps not devoting full time to his responsibilities as legal counsel for the Finance Committee?
Not that I observed. Mr. Liddy was one of those who attended the daily staff meetings, and his attendance was quite regular. I recall only once or twice when he said he had some mission to do outside of Washington and asked if he could have a day off. That was not particularly unusual. I gave him responsibilities that required daily follow-up, and he did the follow-up that was required. For example, just before April 7th, it was necessary for every committee to file with the General Accounting Office a registration statement and to file a qualifying statement with the Treasury Department. And that included not only our committees in Washington, but each of the 51 states. Mr. Liddy had that responsibility, and he gave me regular reports on what was happening and which one was in default and which one wasn't, and I thought administered it well.
I believe you did say earlier that you did have some awareness that he had some responsibilities with regard to the San Diego Convention.
This is something that, as I said, I picked up quite casually, as I recall it, late in May. And I'm not quite sure, but I think it came from Magruder, but it may have come from some other source.
That you would judge that that was not specifically within the scope of responsibilities as legal counsel for the Finance Committee. That was...
No, it was not. But apparently when Mr. Liddy came to the Finance Committee from the Campaign Committee, there was an understanding that he had, or Magruder had with Sloan, that he was going to give something like 96% or 98% of his time to the Finance Committee, but he had a few things still to look after for the Campaign Committee. I don't think I was aware of that at the time, but I heard about it somewhere along the line.
At the time of Mr. Liddy's termination, were you consulted by Mr. Mardian?
Yes. I believe the date was June 28th of last year. Mr. Mardian called me to his office and handed me a memorandum to read. It was to the effect that Mr. Liddy had failed to cooperate with the FBI, had not answered their questions, and Mr. Mardian recommended to me that he be discharged, asked for my approval. I put my approval right on the form, and Mr. Mardian undertook to call Liddy in and tell him that his services were no longer required.
At that point, were you aware of any facts which indicated involvement by Mr. Liddy in the Watergate, in the illegal entry of the Democratic National Committee?
I was not.
Did you at any time have a conversation with Mr. Liddy concerning Segretti?
I don't recall ever discussing Segretti's name with anyone until I read it in the newspapers some months ago. I do not know Donald Segretti and never discussed him with anyone.
Stans, did you have any awareness of an effort on the part of Mr. Magruder to induce Mr. Sloan to falsify testimony?
Not until Mr. Sloan told me about it, and I don't recall how soon it was after it happened. I think it was a matter of some days after it had happened. Mr. Magruder had come to me and asked me how much money Sloan had given to Liddy, and I said I really didn't know, that he should talk to Sloan about it. And that's about the substance of the discussion I had with Magruder. I don't recall whether he named any amounts or not, but he was probing to find out, and I couldn't help him on it.
Did you make any mention to him of any options he would have at such time as he had to make a choice, at such time as he would be required to testify?
Are you referring now to Magruder or Sloan?
Sloan.
I don't recall that I did. I think when Sloan told me that Liddy had asked him to testify to other amounts than he had given him, that my reply to Sloan was to tell the truth. But that's the only advice I gave him.
Do you recall any discussion with him concerning the use of the Fifth Amendment?
No, I don't recall any discussion about that.
just have one more question, Mr. Stans. Did you at any time seek from Mr. Parkinson or Mr. O'Brien in their capacities as attorneys for the committee to re-elect the President, and I must add the Finance Committee to re-elect the President, did you at any time seek from them any status of their report of their work or an explanation of the facts that they were developing?
Well, I don't know that I ever asked for a report, but I was in fairly regular communication with them on a great many things. Most of my conversations with them were with regard to the litigation in which we were involved on a number of fronts.
All right, let me confine my question to the criminal aspects of their representation of the committee, that is, the grand jury testimony that was being required. I'm not inquiring into the civil action matters.
Mr. Sanders, might I observe for the record that Mr. Parkinson was Mr. Stans' personal counsel as well as committee counsel, and of course you're inquiring into the area of attorney-client privileges.
Well, Mr. Stans, I'll defer that line of questioning at this time. Relinquish any further time, Mr. Chairman.
Senator Montoya.
Mr. Chairman. Mr. Stans, going back to the time prior to April 7th, you indicated, I believe, that the total cash on hand was approximately $1.5 million. Is that correct?
I didn't mean to say that, Senator. The total cash received during the entire period of the campaign, I believe, including the cash turned over by Mr. Kalmbach, was about $1,700,000. There never was that much on hand at any one time.
Then are you including in this amount the sum which was turned over from the 1968 presidential election?
I'm including in that figure the amount which was turned over from the 1968 election to the extent that it was in cash.
How much of it was in cash?
About $233,000.
And the other amount or balance of the $680,000 was commingled with the 1972 election fund?
Yes, there was $680,000 received in the form of checks from accounts under Mr. Kalmbach's control that came into the committee on February 3rd of last year from 1968 money principally that became part of the funds of the committee to use from then on.
Then, after April the 7th, what money came to the committee in cash?
There were 3 or 4 items that I'm aware of. One was an item of $10,000 from a Mr. and Mrs. Saunders in Mississippi that came to the committee, but without adequate instructions as to how it should be handled and which committees it should be distributed to. And that matter was not cleared up by the time the $81,000 was given to Mr. LaRue, so it was included in that $81,000 with a request to Mr. LaRue that he give it back unless the parties were willing to allow it to be spread among committees in their name. And Mr. LaRue has confirmed by letter through his attorney that he gave that $10,000 back. That's the first cash item. There was a receipt of $3,000 from 2 men in Omaha that Mr. Sloan received after April 7th and before June 23rd that I was not aware of until the $81,000 was turned over to Mr. LaRue. At that time, I asked Mr. LaRue to handle that also, and either get clearance to deposit the money in the names of the contributors or to return it to them. Mr. LaRue told me sometime later that he had not been able to do it, with the result that the $3,000 was not returned to them. And in order to clear the matter, we ran down the names of the contributors and reported them in our report that was filed last Saturday. That's the second item of money received. There was a third contribution in cash of $50,000 received from a Lehigh Valley Farmers Cooperative through its attorney in Washington, that was received by the treasurer after April 7th and before June 23rd. I was not aware of the details of that transaction and didn't learn about it until October. We have since been able to identify the source of the money, and it has also been reported in our last report to the General Accounting Office. That's 3 transactions. There were some other miscellaneous cash items received from contributors that I don't recall, whose names were reported and the money was put in the bank just as though it were by check, so that it has no distinction.
Did you receive many contributions over and above $10,000 in cash?
Before I answer that, could I complete my other
Yes.
answer, because there was one other transaction. There was a total of $39,000 in cash received in 2 transactions representing funds raised by former Governor Tim Babcock of Montana. We did not get the names of the contributors until recently, and that money has now been reported to the General Accounting Office in our last report. Now, as to your last question, did we receive many contributions of in excess of $10,000 in cash?
Yes.
I would have to guess, Senator. I don't have any list in front of me. I would guess that we probably received 30, possibly 35 contributions of $10,000 or more in cash.
Now let us go into the $20,000 contributions in cash. How many would you say you received in that category?
20,000? Well, you're testing my memory now, and I'm not quite sure. I would say that perhaps 5 less than the number I gave you before that were in $10,000 amounts. So the balance of 25 to 30 would have been 20,000 or more.
Now let us go into the $50,000 bracket. How many of those did you receive?
Well, I have to do a considerable amount of guessing here. I'd say about 10, maybe 12.
Of course, what I'm trying to elicit from you, Mr. Stans, has nothing to do with the trial in New York. I want you to understand that.
I understand that.
Senator Montoya, any answers Mr. Stans would make, he will eliminate any references to that. Is that understood?
Yes, I want him to. Now, let us go
Then you
into...
have to reduce each amount I gave you by 1.
Now let us go into the cash disbursements, Mr. Stans. I believe you mentioned that before April 7th that you authorized or tacitly approved a disbursement of $350,000 to Mr. Kalmbach?
May I correct that slightly? I had knowledge of it after it happened. I raised no objection to it. I don't recall ever approving it as such. And the payment was not made to Mr. Kalmbach. It was made by Mr. Sloan at the direction of Mr. Kalmbach to Gordon Strawn of the White House staff.
Did Mr. Sloan contact you about this contribution before he distributed?
Well, there's where my recollection differs from his. My recollection is that I learned about it from Mr. Sloan after it was distributed, but I really don't think that's material.
What about the $75,000 contribution to Mr. Kalmbach, about which he called you from the Statler Hilton Hotel? Did you approve this?
Well, I gave him the money, as I said, from sources outside the committee, and relying on his good faith and on his assurances to me that it was an important transaction and that he had cleared it with high authorities and it was doing it at their request.
Now, you knew, of course, that Mr. Kalmbach was a man of very high influence in the White House, did you not?
Yes, I did.
You knew that he had a good line of communication with those in the upper echelon in the White House.
No question about it, Senator.
Now, when he mentioned that this request was coming from very high authority, what did go through your mind as to who that person might be?
Well, I knew the people with whom Mr. Kalmbach had very close association and contact. I did not try to identify anyone as the party to that transaction. I did learn about 6 weeks ago from Mr. Kalmbach and his attorney who it was.
Who was it?
He told me the request came to raise the money came from John Dean. That he asked Mr. Dean whether it was a legal transaction, and Dean assured him it was. But being unwilling to proceed solely on that basis, he went to Mr. Ehrlichman and asked Mr. Ehrlichman if it was something that should be done and whether it was legal, and that Mr. Ehrlichman told him it was. Now, that's hearsay, but I got that, as I said, about 6 or 8 weeks ago from Mr. Kalmbach and his attorney.
Didn't Mr. Kalmbach tell you that this was not going to be used for the campaign, that it was going to be used by other purposes?
Yes, he did.
Did that arouse your curiosity?
No, not in the relationship that I had with Mr. Kalmbach, that he had with the White House. Don't forget, Mr. Kalmbach had been entrusted with a very large sum of money that he had left over from the 1968 campaign. He had worked with the White House people in the handling of that sum of money. And I believed Mr. Kalmbach when he said that it was important, but he could not tell me what it was about. And I trusted him.
Well, wasn't it your understanding, Mr. Stans, that when you were collecting this money from contributors, that the money would be used strictly for political purposes?
Oh, Senator, I think I've already said that the money I gave to Kalmbach was not money that had come as contributions.
Well, what money did you give him?
Well, I'll be glad to tell you.
I believe you stated that $40,000 of that was from your safe. And I believe you have stated before to other sources that $35,000 came from contributions made by foreign nationals.
Let me recite that very carefully so that I can correct the amounts as well. $45,000 of the money I gave to Mr. Kalmbach was money that I had received from him just about the time I became finance chairman to use for expenses in the campaign. Not for ordinary expenses, but for unusual expenses that I might incur, such as using jet transportation by charter if I needed to get around the country quickly, or to pay for a vacation because at that point I was working without compensation. So Mr. Comback gave me $50,000 to use for that kind of expense. But as I got into the campaign, I decided I was not going to incur much of that type of expense. I didn't need the money, and I was submitting regular expense accounts for all of the amounts I incurred on behalf of the committee. So I had $45,000 of that in it, still in my safe deposit box. And when Mr. Comback said he had this urgent need for money for a very high purpose on behalf of the White House, I went to the safe deposit box and got that money and gave it to him. That was not money belonging to the Finance Committee.
Did you ever indicate to him that it was his own money that you were giving back?
Well, it really wasn't his own money. It was money entrusted to him, but I'm not sure whether I told him that at that time. I think I did, but he knows it now.
Why would he use the plea that this request was coming from high authority in the White House if he was reclaiming his own money?
Well, he wasn't reclaiming, Senator. He wasn't reclaiming his own money. It happened that that was just about the only money that I could put my hands on to help him meet the needs that he had expressed. And I was willing to give it up because I wasn't going to use it for the purpose for which I had originally received it.
And let us go into the $30,000. Where did you get that?
On the same day, a Philippine national had been in my office and said he was an acquaintance of the president.
Who was he?
I can refer to a paper and give you his name. The Honorable Ernesto V. Lagdameo, L-A-G-D-A-M-E-O. He's a Philippine businessman.
What does he do? Does he deal in sugar?
Well, it doesn't sound like it from the name of the company. He is chairman of the board of Sanitary Wares Manufacturing Corporation. Wares, W-A-R-E-S. I take it to be a plumbing supply firm or something of that type.
It's quite ironical, wouldn't you say?
I think Mr. Lagdameo is a very innocent party here. He came in to see me, said that he was an acquaintance of the president, was prepared on behalf of himself and some of his friends to make a contribution to the campaign, if it could be legally received.
And what about the other friends? Who were they, the other Filipino friends?
They were two of his associates in the same company.
Did you have their names?
I have them here. Mr. Jesus Cabarrus, Sr., J-E-S-U-S, C-O-B-A-R-R-U-S, Sr., who is with the same company, and Mr. I can't pronounce Spanish as well as you can, Senator, Eugenio. Thank you. Eugenio Lopez, Jr.
All right.
There was, at that time, considerable doubt as to whether we could receive contributions from foreign nationals. Back in the 1968 campaign, we had opinions of counsel that it was perfectly proper to receive a contribution from a foreign citizen. And we did receive some contributions of that nature in 1968. In 1972, early in the campaign, we also received a few. And then questions began to arise as to the interpretation of the Corrupt Practices Act as to whether or not we could receive items of that kind. So when this money was offered to me, I took it contingent upon determining that we could accept it. And I got an opinion of counsel shortly after. The counsel for the committee who succeeded Mr. Liddy, expressing the opinion that we could not accept money from a foreign national. So I arranged with Mr. Fred LaRue to give $30,000 back to Mr. Lagdameo and his associates. Since then, and this is more irony, Senator, I have learned that the Department of Justice has held that it would have been perfectly proper to accept a contribution from a foreign national so long as he is not an agent of a foreign principal. But that is the source of the $30,000. Now, I had not accepted the money on behalf of the committee. I was holding it as his agent or an escrow or whatever the legal term might be to determine whether or not I could accept it on behalf of the committee.
Did you finally get the money from Mr. LaRue?
I got the money from Mr. LaRue, and he paid it. He arranged to get it back.
Now, let me ask you this question. Did Mr. Sloan make periodic reports to you about monies which he would disperse?
I think you are referring to disbursements in cash, are you, Senator?
Yes.
From time to time, but on only a very few occasions, Mr. Sloan gave me reports as to how much cash he had on hand. Occasionally I asked him and he would give me the figure. And he also gave me reports as to the contributions received in cash. To the best of my recollection, Mr. Sloan did not ever give me a report of the individual disbursements that he made in cash to anyone.
Did he ever tell you verbally about any big disbursements which he made?
Well, I heard about some that he had made in the past. For example, there was $25,000 given in 1971, almost a year before I joined the committee, to help in the campaign of Congressman Mills in Maryland. I didn't know about that at the time, but after I became chairman, I was told that
the committee and the witness, and so please desist from taking pictures.
At the time I became chairman of the committee, or shortly after, I was told that there was a loan of $25,000 still due from Congressman Mills's campaign. I asked Lee Nunn, who was one of the members of our committee, to check it out and see if we could get it paid, and the report was that there was no money and we couldn't get it paid back. So in that sense, I did learn from Mr. Sloan about some of the earlier transactions. But I do not recall any accounting from Mr. Sloan until June 23rd of last year.
Well, did you know of any disbursements made to anyone in Maryland for the Agnew dinner?
Yes, I was a party to that transaction.
Tell us about it.
In March, Mr. Alexander Lankler was the chairman of the Maryland Committee for the re-election of the President, the campaign committee in Maryland, not the finance committee. And he wanted to be sure that he was going to have adequate financing for his campaign. So on one occasion, he brought in checks from a contributor totaling $150,000 in March. He said that in return, they wanted to promise that on call, we would give him $50,000 of that money to use in the Maryland campaign at any time. I made the promise. I considered it a pledge to him to do so. sometime in May, before the 19th, Mr. Lankler came in and said he would like to call the $50,000 that had been promised to him. He would like it as a loan to be used in the Salute to Agnew party on May 19th. It didn't look as though the receipts of that affair were going to be of a creditable size, and he wanted the receipts to be increased. I gave him the money with the understanding that it would be returned promptly after the affair was over. It was returned to the committee in July. That is the story of that transaction.
Did you ever inquire, or was not your curiosity aroused by requests for the large sums which were being disbursed by Mr. Sloan?
Senator, Mr. Sloan was the treasurer of the committee. He had the cash fund long before I got there. He continued to handle the cash transactions. My only interest was really in knowing who had made contributions in cash, because I wanted to know who our contributors were. I wanted to know from time to time how much cash he had on hand, because occasionally he and I would discuss that subject, and I would suggest that he ought to put some of it in the bank, and he did from time to time. My recollection is that he banked about half of the money that came in cash in the course of time. So that was the nature of my interest and my curiosity.
Why would you attend these budget meetings? Because there were meetings about disbursements then, if you were just interested in contributions.
I don't understand your question, Senator.
Well, you attended quite a few budget meetings with your budget committee to determine how the money would be spent. Now, this did not deal with contributions.
No, it didn't. It dealt with the spending of the campaign.
Now, did you discuss at these budget meetings the big expenditures that were being doled out to certain individuals, such as Mr. Liddy?
Senator, from the time I came, the expenditures, so far as I know, were not big, were not large, except on the one occasion when Mr. Sloan came to me and said Liddy wanted a fairly substantial amount of money, and I went to John Mitchell and I determined that Magruder had the authority to tell Sloan to make payments to Liddy. I was not aware of large amounts of payments.
Did Mr. Mitchell at that meeting tell you what this money was going to be used for, the money that was going to be disbursed to Mr. Liddy?
No, Mr. Mitchell and I did not discuss an amount of money. We discussed only the principle of whether Mr. Magruder had the authority to direct Sloan to make payments. Mr. Magruder said he didn't know what it was about. Mr. Mitchell said he didn't know what it was about, that it was Magruder's responsibility.
Did you make any reports about the state of the finances and also the state of disbursements to anyone in the White House while you were at the Finance Committee as chairman?
I made no reports of any kind on cash transactions, if that's the nature of your question.
No, in disbursements, total disbursements, cash or otherwise.
Total disbursements. I had several conferences with Mr. Haldeman on the subject because I was, as I said earlier, very much concerned, almost irate about the level of spending in this campaign. I thought originally that in the president's position he could be reelected for $25 or $30 million. And when they came to me with budgets of $40 million, which were incomplete, and higher amounts, I objected very strenuously. I insisted that there was overkill in the budgets, in the sense that they were spending money for massive amounts of direct mail, massive amounts of telephoning, massive amounts of advertising that just must duplicate each other. And with that feeling of frustration, which was pretty constant every time we had a meeting, I went to Haldeman a couple times and asked whether he couldn't get some help for me and from the president in holding down the level of spending. Not in terms of any one category, but just let's run this campaign with less money. I don't know what Mr. Haldeman did. I didn't see any significant consequences as a result of those several meetings.
Did he ever get back to you?
I don't recall any specific report. He would take it up and talk about it, but that was it.
Did you ever discuss with Mr. Haldeman any expenditures with respect to any of the activities chargeable to the White House?
No, I don't recall any discussion with Mr. Haldeman about that.
Were you aware that that expenditures were being made for activities which were emanating from the White House?
I was aware that the Republican National Finance Committee was reimbursing the White House for fairly substantial amounts of money each month for matters which were believed to be political, such as mailings and things like that. And when the president became the official candidate of the party, I was aware of those amounts in considerably greater detail because I also became chairman of the Republican National Finance Committee. Yes, the two committees were paying substantial amounts of money for mailings by the White House, for traveling expenses of people in the White House, and for the president's political travel.
And how was this money disbursed to the White House for these purposes? In cash or by check?
Oh, it was all by check. So I don't know of any case in which any money went by cash.
So do I understand that the cash disbursements about which you are aware are as follows? $350,000 to Mr. Kalmbach, which eventually went to the White House through Mr. Strahan, and $75,000 to Mr. Kalmbach directly, comprised of $45,000 from your safe and $30,000 from the contribution by the Filipino National, and then $89,000 to Mr. LaRue on one occasion. 89?
81,000.
81. Well, Mr. Stone says 89, so there's a conflict there. Mr. Sloan.
Mr. Senator, may I say that I think Mr. Sloan's record on a number of cases is that he said 81,000. I'm sure that's the right amount.
And 39,000 on another occasion, is that correct?
That's correct.
And those are the only cash disbursements that, is your feeling, went to the White House?
Well, the $350,000 went to the White House. The $75,000 that I gave to Mr. Kalmbach went for a White House purpose, but I don't know that the White House ever got it. So far as I know, the $81,000 did not go to the White House, and the $39,000 did not go to the White House except for one item, which I have not yet told you about. On November 28th, I got a call from John Dean, or it may have been a day or two before November 28th, which led to an action on November 28th, saying that the $350,000 fund, which had been turned over to him in April, had been depleted by $22,000. $22,000 had been used for some purpose, and since it was a fund for polling, I just assumed that it was for polling. He said that he would like very much to have the fund restored to $350,000 so that if he ever had to account for it, it would be intact. And as a matter of fact, along about that time, we began discussions about whether or not the $350,000 might be given to the Finance Committee and taken into its receipts. But he indicated it was quite important that he have $22,000 to restore the fund. So I gave him $22,000 out of the money that I had received through Tim Babcock on November 28th. he sent Gordon Strawn of the White House staff over to the office to pick it up. Now, the other $17,000 that I had received from Tim Babcock, I gave to Fred LaRue as a payment on account of the $30,000 that he had given me to give back to the Philippine National. So that $39,000 was expended, and those transactions have all been reported to the General Accounting Office in our last report. Now, excuse me.
Senator Montoya, for the record, I might indicate that Mr. Dash's questioning on June 6th of Mr. Sloan at page 1254, he refers to the 81,000 figure consisting of 18,000 and 63,000.
I received that information from the transcript of the interview, which indicates the sum of $89,000. So there must have been a typographical error. But on page 4 of the interview, which we have a record, indicates $89,000. So now let's go back to the cashier's check that Mr. Dahlberg got in Miami and brought to Washington and then went back to Miami and was cashed. Now, was the cashier's check for $25,000, was that in the name of Mr. Dahlberg?
Yes, it was on a Miami bank payable to Kenneth Dahlberg.
Did he endorse it?
Yes, he did. He endorsed it just before he gave it to me.
And who cashed it?
Well, I don't know for a fact who cashed it, except that I gave it to Mr. Sloan at the first opportunity. Mr. Sloan discussed it with our general counsel, Mr. Liddy, and according to Mr. Sloan, Mr. Liddy undertook to cash it.
That is all, Mr. Chairman.
It's been a sort of warm day, and the witness has been on the stand a long time. It's apparent we can't finish today, and so without objection on the part of some member of the committee, I'll be stand in recess till 10 o'clock tomorrow.
Thank you.
Well, for those of you whose appetite for all this is as insatiable as ours, former Commerce Secretary Stans returns to the stand tomorrow, and committee members will question him further about his ignorance of how all the money he raised was spent. There will probably also be some further comment on Stans' recollection that he complained to the White House about the cost of the campaign. Whatever his objections, however, he managed to keep pace with those running the campaign, and the committee to re-elect the president still hasn't spent all the money that he raised. His testimony leads logically to the next witness, Deputy Campaign Director Jeb Stuart Magruder. Stans today recalled that the campaign director, John Mitchell, knew nothing about large amounts of cash given to Gordon Liddy, but that Magruder did know. And it was Magruder's approval that allowed the transfer of the money to Liddy, who's made it very clear that he won't talk about the situation at all.
Stans will talk up to a point, and the committee has been very precise about respecting his request that he not be asked about the Vesco case, where he is currently under indictment. Despite that limitation, committee staffers feel that things have gone very well so far. This afternoon, after adjournment, Impact correspondent Peter Kay talked with Deputy Counsel Rufus Edmonston about the limits on questioning Stans and whether they seriously inhibit the committee's work.
Did you feel at all circumscribed in your testimony by the fact that Mr. Stans is under indictment in New York?
Oh, certainly. I wouldn't call it circumscribed. I would call it using restraint. All lawyers are taught that restraint is the greatest key to a successful lawyer. You can blab off your mouth a great deal and lose your case, but obviously there had to be restraint because what you're dealing with here is maybe prejudicing the judicial system, which is one of the separate but equal branches of the government.
You said when we talked earlier one time that all of these witnesses had been pre-interviewed extensively by the committee staff, and that, if I remember correctly, there were very few surprises. Were there any surprises in Mr. Stans's testimony or lack of memory today?
Now, I will not comment on that for this reason. Perhaps there were some surprises. Perhaps there were some things that were not said in the pre-interview, but we will reserve that for further corroboration of other witnesses. There could have been. Now, obviously, this memo that I introduced was a surprise. Its physical presence was a surprise, but I wouldn't comment on or evaluate Mr. Stans' testimony at this time, because that's the job of the American people in the committee, when all the evidence is in.
Do you plan to call Mr. Dick Whitney, or I know you're going to talk to the Attorney General, but are there plans to pursue this memo with other potential witnesses?
Well, I'm sure that we follow out all investigative leads, whether coming in anonymously or by name, and so everything brought before the committee will be followed up, including anything in this memo.
One final question, and I suppose you'll get another crack at Mr. Stans tomorrow, but he was billed as the first of the really big names. I think most people feel he acquitted himself pretty well today in his testimony. How do you feel today's questioning went? Are you satisfied with it? Are you disappointed that certain ground wasn't covered?
Oh, I don't think we even got started today. I covered what I could cover, and we'll leave that up to the senators tomorrow. And so I've expressed no disappointment or joy either one. I'm simply glad today's over. It's been hot.
Certainly has, and we'll let you go now. Thank you, Mr. Edmonston.
Great.
Edmonston did surprise a lot of people today, including Stans, by referring to a Magruder memo that told of $1 million political fund Stans had as a Commerce Secretary. Stans promptly denied that the fund even existed. Edmonston then surprised a lot of people in the audience by not pursuing the matter further. But, as you just heard him assure Peter Kay that he hadn't forgotten about it, and he predicted there will be further questioning about it tomorrow.
If Stans finishes in time, Jeb Stuart Magruder, the assistant campaign director, is expected to be on the witness stand tomorrow afternoon. He could resolve some of the questions and contradictions that have been raised so far, especially the question of why he told campaign treasurer Hugh Sloan it was all right to pay large sums of money to Gordon Liddy. Magruder could explain a lot of things, or he could merely recall, as others have done, that he was following orders without thinking about why certain moves were needed.
Alan Barth of Washington, author of the book Government by Investigation, and Bill Greenhall, Associate Dean of the Georgetown University Law School, are with us now. And Mr. Greenhall, I'd like to begin by coming back to the point that was raised by Mr. Stans' attorney at the beginning as to whether or not these proceedings would prejudice Mr. Stans' eventual trial, particularly the one in New York. From your viewpoint of what Mr. Stans has said thus far, at least, has anything come up that you think that would prejudice a jury against him?
I think any potential juror in the Southern District of New York would be very hard-pressed, in my opinion, to find prejudice against Mr. Stans based on today's proceedings. You had the demeanor of the witness, the credibility of the witness, his preciseness. I think it probably, if anybody is examined on voir dire to say that they've even seen these proceedings and his testimony, he'll probably be something in his favor rather than to his detriment.
What do you think about it, Mr. Barth?
You know, I hope heartily that today's proceedings will at long last, lay to rest the anxieties of those people who suppose that a congressional investigating committee automatically makes impossible a fair trial for a witness who has come before the committee. That seems to me to be by no means the case. Mr. Stans did himself some good today. He also did the committee some good because he shed some light on matters that are of importance to the committee and of no relevance to the trial, which is to take place in September. In any case, it seems to me that the argument that his lawyer made to the committee against requiring his testimony is an argument that ought to be made to the court in September if at that time they really believe that the committee hearing has in some way prejudiced his rights. So far, at least, the committee showed great respect for him, for his rights as a defendant, and for his rights and dignity as a human being. It has, this committee, an enormously important function to discharge. It must assert the countervailing power of the legislative branch of the government in determining how well and how faithfully the executive branch has discharged the laws. And that's a function that should not lightly be cast aside. It's far too important to be carelessly abandoned.
Of course, Mr. Greenhall, this is the first time we've seen it. All these major legal points raised. But as we go down the road, the testimony, of course, the completion of Mr. Stans' testimony tomorrow, later possibly Mr. Magruder, Mr. Dean, and on down the line.
Immunity boys.
Right, but also the rights of the individuals as defendants or potential defendants. I mean, this is also a very crucial thing that somebody's going to have to watch throughout this. Is that not correct?
That's true, but and you have yet to see the invocation of the Fifth Amendment privilege in these proceedings, which leads me to believe there is a fantastic amount of staff work being done behind the scenes to try to straighten out all the ground rules and make these proceedings as fair as possible. I'm terribly impressed, and maybe, I don't know when that first witness will feel that they will have to invoke the Fifth Amendment.
Staff work, you mean by the staff of the committee
Yes.
doing their work so they
That's
won't
right.
have to ask a question?
You know, the thing that irritated me about my former governor, Vice President Agnew, was when he lambasted these proceedings late yesterday or sometime in the papers. There are three great concepts of due process, and that is notice of what you're dealing with, 2, counsel in order to assist you, and 3, the fact that at any time that you're in one of these predicaments and you do feel that a truthful answer will tend to occur, you may invoke the Fifth Amendment. And you have noticed, because every single one of these witnesses has been thoroughly interviewed. They know precisely the areas in which they'll be examined. 2, they always have a lawyer at their side if they want one. And they can always invoke the Fifth Amendment if they firmly believe that a truthful answer will tend to incriminate them.
There's not too much of a deep analytical nature that cries out to be dropped on you at this late hour. Just a couple of points and you can go on to bed. First, a few words should be said, though, about Herbert Porter, the young Nixon partisan who committed perjury. Senator Ervin and Senator Baker, using quotations and very warm words, respectively, sent him on his way with thanks for finally telling all without asking for immunity from prosecution. And Porter spoke of atonement and of finding a basic weakness in his character. It was very dramatic and personal and very sad. And then came Maurice Stans, appearing and talking with the self-assurance of a man having been at the top levels of power in this nation for a very long time. He is obviously comfortable in the company of both senators and presidents. Porter, on the other hand, was awed by even the mention of the president's name. That was one of the reasons he said he even did what he did. It was one of the flaws in his character. Stans confessed to no flaws, no weaknesses, no wrongdoing. And the contrast in the two men, Herbert Porter and Maurice Stans, was striking, to me at least. And I found myself wondering what quotation from Shakespeare or the Bible would Senator Ervin use to send Maurice Stans on his way tomorrow. Well, we shall all see. And until tomorrow night, I'm Jim Lara for Peter Kay and Robert McNeil. Thank you and good night.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.